So I'll let Mr. Jefferson in. Okay. This is the people of the state of Michigan versus Earl Jefferson, case number 22 F56310. Mr. Jefferson is charged in count 1 with weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3, weapons, felony firearm. Count 4, police officer assaulting, resisting, obstructing. Count 5, police officer fleeing, 4th degree. Count 6 is a misdemeanor. He's placed on notice that he's a habitual offender 4th. May have your appearances. I'm sorry, habitual offender 3rd. May have your appearances.
Good morning, Your Honor. Irvin Bailey on behalf of people E84009.
Good morning, Your Honor. May it please the court. Mark Brown, appearing on behalf of Mr. Jefferson. My opinion number is 39562. I have no objection continuing via the Zoom technology. Mr. Jefferson is present via Zoom. We'd like to set a date, perhaps a PCC initially. I'd like to get a copy of the discovery.
All right, Mr. Jefferson, if you can please unmute yourself and state your name for the record.
Mr. Jefferson, press the button in the lower left-hand corner of this little microphone.
Okay, I got it. I'm unmuted. My name is Earl Jefferson.
All right, good morning. Today is
Good
the date
morning.
and time set for a probable cause conference. Ms. Bailey, you sent discovery?
Yes, ma'am. It was sent Friday.
Mr. Brown, if you can please check to make sure that you have the discovery. If not, please let the court know.
Okay.
And let the court know. We'll make sure that it's provided to you.
Okay, I'll certainly check, Judge. Thank you.
And I'm going to schedule this for an exam to occur. How is April 4th at 11 a.m.?
I will be, I'm not actually in the trial, but I'm sure I'll be in trial preparation. I have a murder trial that starts on the 5th. So I prefer if we could do it after that.
What about that Friday? April 8th. Wait, no, that's not a good day. I can do Monday, April 11th at 10.
We can set it for that date. If I'm still in trial, we'll have to change it, but we can set it for that date.
Want to do it before your trial?
Pardon me?
Want to do it next week?
No.
Okay. All right. So then we'll set it for an exam to occur on April 11th at 9 a.m.
Thank you very much, Judge.
All right. You're welcome, Mr. Jefferson. You'll have to come into 36th District Court on April 11th. I said at 9, but I meant 10 a.m. at 10 a.m.
Okay.
And Judge, who's the prosecutor on this case there?
It's Miss Bailey. Bryn Bailey is the prosecutor in here today.
Okay, I'll check to see if I have the discovery by mail. Thank you very much.
All right, thank you.
Everyone have a good day. You can sign off, Mr. Jefferson.
Okay.
Ready on Stroud?
Yes, ma'am. I believe he's in the waiting room.
first name. Joseph.
Yes, ma'am.
All right. This is the people of the state of Michigan versus Joseph Stroud, case number 22-056-3080. Mr. Stroud is charged with count 1 with controlled substance delivery manufactured less than 50 grams. Count 2, controlled substance delivery manufactured less than 50 grams. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Your Honor. Neighborhood Defender Service by Lauren Anderson, P85191, on behalf of Joseph Stroud, who is present on Zoom.
All right, thank you, Mr. Stroud. Please state your name for the record.
Joseph Jordan Stroud IV.
Good morning.
Good morning.
Today is the date and time set for a probable cause conference. Ms. Anderson, have you seen discovery?
I have not yet, Judge.
It was sent to the generalized NDS discovery email on Friday.
It'll probably come through today then for me directly. If we could just set it for an exam date then.
All right, so the court is just gonna provide a, just make sure that you have discovery. If you don't have it, I'm gonna give a discovery cutoff date of a week from today, which is the 28th. And I'll set this.
Madam Clerk,
Hold on, we're on the record, Mr. Margolis, just a second. I'll set this for an exam. Occur on April 4th at 11 a.m.
That's perfect, Judge. Thank you.
All right, so Mr. Stroud, you'll have to come into 36th District Court on April 4th at 11 a.m.
Okay.
All right?
Yes.
There's nothing, this matter is concluded.
Thank you. Have a good day, everyone.
All right, you too. Ready on Jones?
ready, Your Honor.
Letting Mr. Jones in. This is the people of the state of Michigan versus Drake Jones, case number 22-F55636. Mr. Jones is charged in count 1 with weapons carrying concealed, and in count 2 with police officer assaulting, resisting, obstructing. May I have your appearances, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Jeffrey Schwartz, P32076, on behalf of Mr. Jones, we are free to go forward by Zoom. And he is going to waive his exam after being appraised of his rights and the burden of proof.
Thank you, Mr. Jones. State your name, sir.
Drake Jones.
Good morning, sir.
Good morning.
Your lawyer has indicated that you'd like to waive your right to your exam. Is that correct, sir?
Yes.
Mr. Jones, you understand, as your lawyer has explained to you, that you have a statutory right to have a preliminary examination. At a preliminary examination, the prosecutor would call witnesses and would have to prove by a probable cause standard that you committed these crimes they're accusing you of, and that the crimes occurred in the city of Detroit. Do you understand that?
Yes.
But you're choosing to not have your exam held, but to have your case move forward to the circuit court for further proceedings.
Yes.
Has anyone forced, threatened, or promised you anything to get you to waive your right to your exam?
No.
And Ms. Bailey, do you have any objection to the waiver?
No objection, Your Honor.
The court will accept your waiver, sir. You'll be bound over to the Third Circuit Court for arraignment on the information. And that arraignment will occur 2 days from today, which is April 4th at 9 a.m. Mr. Schwartz and Mr. Jones, do either of you have a problem with the court signing the waiver form on your behalf?
No, Your Honor.
Any problem with that, Mr. Jones?
No.
Okay, so April 4th is your next day, sir. Good luck to you.
No.
Hello, Madam Clerk.
Hold on one second, please. Wayne County, good morning.
Good morning, Your Honor. My partners went to get your people, and I'm not sure who they went to get, but they left, and they should be back shortly.
Okay, thank you.
You're welcome. Thanks.
All right, so now I can check in the new lawyers. Mr. Tuttles, good morning.
Good morning, Your Honor. May I please, well, let me say good morning. I have a matter scheduled for you in person at 10 o'clock, Mr. Sanders. And I spoke to Mr. Sanders this morning to make sure he was going to be there. And the last time Mr. Sanders was scheduled to be in your courtroom, Your Honor changed the date, and I neglected to give that new date, which is today. I neglected to give that new date to Mr. Sanders because he is at work as we speak. So what I was going to do is try to come in and perhaps get a different date other than today's date. And I will make sure this time I will inform Mr. Sanders, who has never had a reason to miss court before. Mr. Sanders' first name is Nathan.
All right, thank you. I'm gonna call the Nathan Sanders file. This is the people of the state of Michigan versus Nathan Sanders. Case number 22 S55407. Mr. Sanders is charged in count 1 with weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carried concealed. And counts 4 and 5, weapons, felony firearm. May I have your appearances, please?
Your Honor, Irvin on behalf of the people, 384009.
Good morning, Your Honor. May it please this honorable court, Antonio D. Tuttles on behalf of my client, that is Mr. Nathan Sanders, who is physically not present in your courtroom this morning. I dragged to the court with physical presence, and nor is Mr. Sanders present via Zoom. I asked the court for this particular case to waive Mr. Sanders' virtual appearance as well.
All right, thank you. The court will waive Mr. Sanders' presence for today's hearing. This matter is scheduled for an exam to occur at 10 o'clock. Mr. Tuttles, you're unable to proceed at 10?
I'm not able to handle that matter at 10 o'clock, Your Honor. As I stated earlier, the last time Mr. Sanders was scheduled for court, the court itself adjourned the date to today's date. I neglected to inform Mr. Sanders in a timely fashion that he had a court date today. I did speak to Mr. Sanders this morning, and Mr. Sanders is at work.
All right, so the court has had an opportunity to review the file. It looks like this case was initially up for PCC on February 3rd. It was scheduled for an in-person exam on March 2nd at 10 a.m. The court received an email from the prosecutor, Ms. Wolf, asking for an adjournment because necessary police officer witness was involved in an on-duty incident and would not be available for a few weeks. So the court did adjourn the exam at the prosecutor's request today at 10 a.m. The court will allow you an opportunity to notify your client, Mr. Tuttles, and to get him into court. And I will give you a new date of April 5th at 11 a.m. for your preliminary examination.
Your Honor, say 11.
11. Thank you. You're welcome.
Your Honor, April 5th, I know I have my docket is full that day for an in-person. So can I have a date? Can I have a week after April 5th, which should be April 12th?
I can do April 12th at I can do April 12th at 10 a.m.
Okay. 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 That's April 12th at 10.
Yes.
Okay, and I'll be sure to tell Mr. Sanders today.
All right.
Okay, so that's in person, April 12th at 10 o'clock.
That's correct.
I appreciate the court's indulgence.
All right, thank you.
All right, bye-bye.
Good morning, Mr. Margolis.
Hi,
Who
I'm
you
here
got?
on Tyrone Irvin.
Have you spoken with Mr. Irvin? Irvin?
I have spoken to him. He was supposed to be in my office at 8:15 and he's not here and he doesn't answer.
Let me see if this is him in my waiting.
I was sent the discovery on Friday afternoon and I tried downloading it and for some reason it doesn't open. So I need another link.
Okay. Were you retained on this case, Mr. Margolis?
No, I'm appointed.
Okay. All right, so that is not him in the with the iPhone. Good morning, ma'am, with the iPhone. What's your name?
Yolanda Scandrick.
Say your last name again.
Scandrick.
You have the case in my courtroom?
Yes.
I think you're in the wrong place. I don't see you on the docket.
No, I'm here for someone else. I don't have a case myself.
Oh, what's the person's name?
Tyron Dimmings.
Okay, so you'll have to watch over YouTube. You'll have to watch the proceedings over YouTube.
Okay, how do I go about doing that?
You can go to the 36th District Court website and go to courtroom 234, watch over YouTube. You'll be able to see the proceedings.
Okay, thank you.
You're welcome. All right, Mr. Margolis, do you want to adjourn for a week to see if you can locate your client? How do you want to proceed?
I can try. Yeah, if I can do that, that would probably be best. I did talk to him, so I don't know what his.
All right, let me call the case and we'll just put it over.
Okay, thank you.
No problem. This is the people of the state of Michigan versus Tyrone Irvin, case number 22 F6277. Mr. Irvin is charged in count 1 with weapons carrying concealed, count 2 police officer assaulting, resisting, obstructing, count 3 weapons felony firearm, count 4 is a misdemeanor, and aggravated resistance.
Good morning, Your Honor. Grim Daly on behalf of the people, P84009.
Your Honor, Elliot Margolis, P28078, on behalf of Tyrone Irving.
All right, good morning. The
Good
court is
morning.
going to waive Mr. Irvin's presence for today's hearing. Today is the date and time set for a probable cause conference. Mr. Margolis asked to discovery. You can make your record.
Yes, I was sent a discovery link on Friday afternoon, but for some reason it didn't download. It indicates can't open. So if I could get another link, I would appreciate it.
All right, Ms. Bailey, can you
And I'll try to
provide-
reach my client again, but you know, I did call him this morning. No answer.
Thank you. Ms. Bailey, can you please provide or resend that discovery no later than a week from today, which is the 28th of March?
I did not hear that, Judge. I'm sorry.
I asked the prosecutor to resend the discovery no later than a week from today, March 28th.
Okay, but can I have a mediation at 8:30 in the morning that's going to take all morning on the 28th. Can we get this over to the 29th?
Yes, the court will adjourn the PCC until Tuesday, March 29th at 8:30 a.m. Your client will need to appear over Zoom for that day.
I understand that, Judge. Thank you. I appreciate that.
No problem.
Thank you. Bye-bye.
Thurn Wayne County, what's your name? Unmute yourself.
This is Dimmings.
Say your name.
Tyron Dimmings.
All right. Ms. O'Meara, do you need a breakout room?
No, Your Honor, I went to visit him at the jail.
Okay. Is this your case, Ms. Hadid?
Yes, Judge, it is.
All right. This is the people of the state of Michigan versus Tyrone Dimmings, case number 20-F59208. Mr. Dimmings is charged in counts 1, 2, and 3 with assault with intent to murder. Counts 4, 5, and 6, assault with intent to do great bodily harm less than murder or by strangulation. Count 7, weapons, firearms, discharge in or at a building causing injury. Count 8, weapons, firearms, possession by a felon. Count 9, weapons, dangerous weapons, carrying with unlawful intent. And counts 10, 11, 12, 13, 14, 15, 16, 17, and 18. Weapons, felony firearms, second offense notice. Mr. Dimmings is placed on notice that he's a habitual offender before. You have your.
Good morning, Your Honor, and to your staff. Rana Hadid on behalf of the people, P62243.
And good morning, Your Honor. Catherine O'Meara, P53823 on behalf of Mr. Dimmings.
All right, thank you. Mr. Dimmings, state your name for the record, sir. You got to unmute again.
Tyron Dimmings.
All right, good morning. Today is the date and time set for a probable cause conference. Ms. O'Meara, have you received discovery?
I have not received discovery. I did communicate with Ms. Hadid this morning, and she assured me that she'd be sending that today. We're just asking for a preliminary exam date, and I'd like to address bond, and I'm anticipating that the court would want a bond report prior to doing so. So I'm asking that that be prepared.
Thank you. The court will order that discovery be provided to the defense no later than a week from today, which is the 28th of March. And I will schedule this matter for an in-person exam. Just a second. I can do it if you all are available on the 29th at 1:30, or else we can go to April 4th at 1:30.
I could do the 29th at 1:30.
I can too, Judge.
All right, so then we'll set this for an in-person exam to occur on March 9th at 1:30. The court will also order a pre-trial services report. And we'll have that prepared for the 29th.
Thank you.
Your Honor.
You're welcome.
Have a good day, everyone.
All right, you're all set. Thank you. Good morning, Mr. Goldhoff.
Am I done, drill, Judge?
Yes, you are.
Okay. All right. Thank you. Have a blessed day.
Good morning. You too, sir. Are you ready on Austin?
I have not made contact with him. I've been trying to get a hold of him. I did get the discovery. Has he come online?
Yes, he has.
Oh, great. Thank you.
Mr. Austin, if you can please turn on your camera.
Okay, I'm sorry, just give me one moment.
Okay, I'm gonna place you in a breakout room with your lawyer.
Okay.
Thank you, Ron. Thank you.
one. Very good.
Oh, very good.
Yeah.
This is Mr. Harrison.
Yes, Your Honor.
Are you ready, Mr. Bailey? This is the people of the state of Michigan versus the Janai Harrison. Case number 21F61005. Mr. Harrison is charged in counts 1 and 2 with weapons carrying concealed. May I have your appearances.
Good morning, Your Honor. Grim Bailey on behalf of people, P84009.
Morning, Judge. Neighborhood Defender Service by Jackie Polkowitz, P81653 on behalf of Janai Harrison, who is present in the courtroom. Janai, will you state your name to the judge, please?
My name is Janai Harrison.
All right, good morning, Mr. Harrison. Today's the date and time set for a preliminary examination. Are the parties ready to proceed?
Your Honor, people are not prepared to proceed. Subpoenas and reminder emails were sent to the officer necessary, and he is not approved today.
Your Honor, we move to dismiss the case without prejudice.
All right, thank you. So this matter was scheduled for exam to occur at 9 o'clock this morning. It's now 9:18. The necessary witnesses failed to appear. Because of that witness's failure to appear, the court is going to grant the defense's motion dismissing this case against you, sir. Please understand, Mr. Harrison, that the dismissal is without prejudice, which means that they can reissue it if they're later able to locate their witness. But it's dismissed today, so we're lucky.
Thank you, Judge. Yes, Judge. Okay.
So are you ready on Baldwin? This is the people of the state of Michigan versus Daniel Baldwin. Case number 21F62481. Mr. Baldwin is charged in count 1 weapons carrying concealed. You have your.
Good morning, Your Honor. Grim Bailey on behalf of people, P84009.
And Neighborhood Defender Service by Jackie Polkowitz, P81653 on behalf of Mr. Baldwin, who's present in the courtroom. Mr. Baldwin, will you state your name to the judge, please?
My name is James Baldwin.
All right, good morning, sir.
Good morning.
Today's the date and time set for a preliminary examination. Are the parties ready to proceed?
Your Honor.
We're ready, Judge. Yeah.
The court is going to order all witnesses sequestered. There will be an exception for the officer in charge. Ms. Bailey, how many witnesses do you have?
1, Your Honor.
All right. You can call for shifts.
Your Honor, at this time, we will call Officer Burks. Sir, can you please raise your hand? Swear or affirm that the testimony will be filed. Sit right at that chair. There's a microphone right next to you that one. Can you pick up the entire base of that microphone? Make sure that the red light is on. We need you to hold the microphone and speak loudly and clearly. Thank you. Good morning. Can you please state your name for the record?
First name Cameron, C-A-M-E-R-O-N. Last name Burks, B-E-R-K-S.
Are you currently employed?
Yes, I am.
Where are you currently employed?
The teacher of the department.
In what capacity?
That's the teacher of this officer.
And how long have you been employed in that way?
Approximately 4.5 years.
Were you employed as a street police officer on December 8th, 2021?
Yes, I was.
Did you work on that day?
Yes, I did.
Were you by yourself or with the partner?
With, two partners.
What were your partner's names on that day?
First partner's name is Quentin Eagle. Second partner's name is Ryan Paget.
Okay, so I'm gonna need, can you spell, is Clinton common spelling?
Yes, it is.
Okay, what about the last name?
Elam, E-L-A-M.
And then the second partner,
First name is Ryan.
common spelling?
Yes.
Okay,
Last name Paget House.
I'm gonna need you to spell that one as best as you can for me.
It's gonna be P-A-J-A-K-O-W-S-A-I.
Thank you. Are you in full or modified uniform?
Not my name.
What is that modified uniform look like?
It's gonna be green pants, black shirt with the outer exterior vest. Police sergeant.
And were you on foot or in a scout car?
In the scout car.
Was the scout car fully or semi-marked?
It was 7.
What does a semi-marked scout car look like?
So black scout car, it's got like dark Detroit police emblem on it, so it's kind of hard to tell. Doesn't have overhead light, light bar on top of it.
Did your duties as a police officer take you to the area at or near 15415 Harbor Avenue?
Yes,
Is that here in the city of Detroit?
yes, it is.
County of Wayne?
Yes, it is.
What if anything brought you to that area?
I observed individuals that have lived experience.
And what led you to believe that?
As I got, I think it was eastbound on Harper, seen an individual wearing all black. His right hand was put together with waistband, left arm was free. As I passed this individual, he looked over his shoulder, he back to the stuff.
Okay, so, and were you driving?
Yes, I was.
And what, if anything, did you observe this individual do next?
Well, as I passed him, I lost, sight of him for a minute. Swung back around, and then there was a lick for red, 150.
I need you to just speak a little loud.
Oh, I'm sorry.
Did you see this?
Bend that microphone.
Better?
Yeah, turn it towards you. Yeah.
Say,
Did you, so you said that you figured that this person went to a liquor store. What made you think that?
because I didn't see him on the street anymore.
So what, if anything, did you do next?
My partner and I had scout car. We went to the liquor store.
And upon entering the liquor store, what, if anything, did you observe?
I observed the same individual I seen walking on the sidewalk. Standing near the counter. And, I, observed him, he had a very large L-shaped hole in his, hoodie pocket.
And what, if anything, did you do next?
I immediately ordered him to be raised, which he complied.
And then what?
I would cover the black and silver somehow. Okay, from his, hoodie to the pocket.
What, if anything, did you do after removing the handgun from the hoodie?
I don't know. I don't know.
What did you do next?
Believe, I don't know if I personally placed him in handcuffs, but I believe, maybe my partners did.
But to the best of your recollection, this person was placed into handcuffs.
Yes,
Do you see that person here in the courtroom today?
yes, I did.
Could you please point to him and tell me something he's wearing?
Like gray button shirt.
Governor, let the record reflect that the witness has identified the defendant. Remarkable so. What, if anything, did you do with the handgun next?
I don't recall if I gave it to my partners to be safe or if I made it to myself. The handgun was secure.
Objection calls for speculation.
Your response?
Your Honor, he's testifying as to, he remembers that it was made safe, he just doesn't remember specifically who did it. But he does know.
All right, do you recall if the weapon was made safe?
I don't, it would have had to be them. We would let it work, but it,
You don't have anything recollection of it?
not at the moment.
All right, sustained.
Did you, what, if any, further investigation did you do next?
I myself, other drivers, I was doing any further investigation, however, my partner would have done that.
Objection again calls for speculation.
Right. What was the question again?
What, if anything, was done next?
All right, can you tell me your answer?
I said that I was the driver that day, so I wouldn't have done any further investigation, like whether individual had concealed missile license or lien. That would have been my partner.
Did you ask the defendant if he had a concealed pistol license?
I don't recall if I did myself. I did hear Paul.
Objection, hearsay and calls for speculation.
Well, Your Honor, as far as the hearsay, if you heard what the defendant said, that's part of the opponent and an exclusion of hearsay. And speculation, just because he doesn't remember, he was the one who asked the question, doesn't mean he can't recall that the question was asked and that the defendant did give an answer.
Your Honor, this witness has testified, I think, on the past 2 or 3 questions, that he doesn't recall what happened further, whether the gun was occurred, what happened with regard to the investigation. He's already been asked the same question 2 or 3 times. I don't believe there's anything more for this witness to testify to.
Your Honor, he hasn't been asked the same question 2 or 3 times, and that's one of their questions.
All right, yeah,
his memory.
All right, so, Officer Burks, you were testifying that you heard your partner say something, is that correct?
That is correct.
Or ask a question?
Yes, ma'am.
Did you hear the response from the question?
No, I do not recall the response.
Okay,
I have no further questions.
thank you. Cross-examination.
Just very briefly, Officer Burks, you testified that you were driving the vehicle, patrol vehicle that night,
Yes, I was.
and this was at nighttime,
Yes, it was.
so it was dark outside,
Yes, ma'am.
and you testified that you observed a person wearing all black,
Correct.
and you believe he was armed,
Yes,
and you were driving at this time,
yes, I
and you are, say, 20, 30 feet away from this individual,
could be.
and your eyes are obviously primarily focused on the road you're driving.
Yes, ma'am.
Okay, and you said he put his right hand on his waistband.
His right hand was punched against his waistband.
Okay, and you saw that clearly from 20, 30 feet away in the dark.
I suspected that, yes.
Okay, you didn't see a weapon of any kind at that time.
Not at that.
You didn't see contraband of any kind at that time.
No, ma'am.
And my client wasn't doing anything illegal, not jaywalking, nothing at the time.
No, ma'am.
Okay, then you followed him into the liquor store,
Correct.
and that's when you see a bulge,
Yes,
and you order him to put his hands up, And then you go over to him, reach into his pocket,
Correct.
and recover a weapon.
Yes, ma'am.
To make it crystal clear, at that time that you recovered the weapon, you did not know whether my client possessed the CPL.
I don't recall if the question was asked after I had already recovered the handgun or not, but it was pretty quick that I recovered it.
I have no further questions, Judge.
No, wherever you're at. All right, thank you, Officer Burks.
Thank you.
Any other witnesses on behalf of the people? This is on behalf of the defense.
No, Your Honor.
All right, Ms. B.
Your Honor, at this time, the people moved the bind over, we did hear today from Officer Burks that the observed defendant walking down the street. We're at 15416 Harper Avenue, here to Detroit, County of Wayne. We observed the defendant to be clutching his waistband, hoodie area, Your Honor. And when he turned around to make further investigation, he made an educated guess as to where the defendant might have gone. And upon entering that location, he did again see the defendant with an obvious L-shaped bulge, Your Honor. At this time, he recovered a handgun concealed on the defendant's person. In an appropriate manner, Your Honor, this is what had met the burden of proof by a probable cause standard and asked the court findings.
Thank you. Your Honor, obviously the first glaring issue in this case is that the people have failed to offer any evidence that my client did not possess a concealed pistol license at the time he allegedly carried a concealed pistol on his person. I think there is obviously it is glaring from the testimony of this officer that he has no idea with regard to whether or not my client had a CPL, which would render his conduct perfectly lawful and render the stop and search of this person completely unlawful, because the people have failed to offer any evidence with regard to that element of carrying a concealed weapon. I don't believe they've met their burden. I believe dismissal would be proper. Additionally, Judge, even if the court were to see past that element, which again, I don't think it should, but if it were, a L-shaped bulge alone is not reasonable suspicion to stop and frisk and search someone's person. This officer testified that he saw a black man in a hoodie walking down the street holding his waistband, walk into a liquor store, and then a bulge in his pocket. Judge, the officer needs to set forth reasonable articulable suspicion that a crime has been committed, and he cannot do that in this case. That is especially the case in light of the fact that he had no idea whether this individual possessed the CPL. I'll leave it at that, Judge. We object to the bind over and ask this court to dismiss the case.
Please let me respond, Your Honor. One, people aren't required to prove whether or not the defendant has a CPL or not. That is not an actual element. The presence of a CPL is in and of itself a defense, Your Honor, which at this time we're not concerned with. We're just concerned with whether or not there's enough evidence that a crime was committed and the defendant was the one who committed it. Additionally, Your Honor, the officer testified that he had a lot of different things. One, the defendant was walking and holding his waistband front area of a hoodie. He checked over his shoulder numerous times as the cops drove by, Your Honor. And when the officers entered, it became apparent that it was an L-shaped bulge that, due to their training, Your Honor, they believed it to be a handgun. And lo and behold, it was. Have met the burden of proof by a probable cause standard 9.
Your Honor, just one line briefly. I moved to strike the statement with regard to training and experience, which was not specified to on record. Yes, thank you. Okay, thank you.
So the court heard from Cameron Burks, who's a Detroit police officer. He's been so employed for the last 4.5 years. He's working on December 8th of last year with two partners, Officer Elam and Officer Hudson. They were modified uniforms, semi-marked scout car near the area of 15415 Harbor in the city of Detroit. And they observed an individual who was identified as the defendant wearing all black and with an L-shaped bulge in his hoodie pocket. The officer testified that defendant was looking over his shoulder, continued to look in the direction of the officers, went inside of a store, and based on those actions, Officer Burks patted him down, felt what he believed to be a firearm, and recovered a black semi-automatic from his pocket. The defendant is charged in count one with weapons carrying concealed, and the court is satisfied that the people met the burden of proof by a probable cause standard. The court recognizes that whether or not Mr. Baldwin had a CPL is in fact an affirmative defense. And the court also recognizes that firearms, including especially in the pockets, they have a very distinct shape that is pretty obvious to the individual that is making that observation. So the court is satisfied that the people met the burden of proof. The defendant will be bound over to the third circuit court for arraignment on the information. His arraignment will occur 2 weeks from today, which is the 4th of April at 9 a.m. Mr. Goldpaw, are you ready?
Yes, we are.
This is the people of the state of Michigan versus Deshaun Austin. Case number 22-F56-123. Mr. Austin is charged in count one with weapons, taser, possession, sale of. May I have your appearance.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Your Honor, John Goldpaw, P 30758, on behalf of Mr. Austin. Mr. Austin, would you please put your name on the record? You have to unmute yourself, Mr. Austin.
Yes, Deshaun Austin.
All right, good morning. So today's the date and time set for a probable cause conference. Mr. Goldpaw, have you received a summons?
Yes, I have. It was forwarded to me by Ms. Wolf last week. I've had contact with Mr. Austin today. I've gained his his contact information. Your Honor, at this time, we would ask for a live exam to be set in this particular matter.
All right, thank you.
Or in person. Exam.
Yes. How is April 5th at 9 a.m.?
If I have a quick moment, Your Honor, so check my calendar. Your Honor, could we go over, I have a number of, Your Honor, if it could be later in the day, that would be perfect.
All right, how's the at 11 a.m.?
That'll be fine, Your Honor. I can bring my, no, Your Honor, if we could go a couple more days late, I have a number of matters that day. All on Zoom, and I'm not going to be available on the 5th.
All right, how's April 7th at 9 a.m.?
April 2nd?
7th.
Oh, 7th, I'm sorry. Yes, that'll be fine, Your Honor.
All right, so Mr. Austin, you're going to come into 36.
Oh, hold on, Your Honor, I apologize. Let me just check. I think I have the wrong date there. Oh, nope, I am way wrong. I apologize, Your Honor, for this. I am not good with computers.
It's okay.
I just am terrible. Your Honor, yeah, that's not a good day. Your Honor, would it be possible to go to the 6th of April?
Yes, April 6th is good at 9 a.m.
That'll be fine, Your Honor. Thank you very much.
All right, so Mr. Austin, you'll have to come into 36th District Court on April 6th at 9 a.m.
Okay.
All right, we'll see you then.
Thank you.
Okay.
Thank you, Your Honor. And Mr. Austin, I'll send you that discovery material and you can send me back the information I've requested. Stay in
Okay.
touch. Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. Sir, in Wayne County, what's your name? You need to be unmuted first.
How you doing? My name is Matthew Mercer.
Matthew Mercer, okay, we're waiting on your lawyer, Mr. Mercer. As soon as he gets here, I'll call your case, okay?
Okay.
Thank you. Good morning, Mr. Clements.
Hey, Judge, good morning.
What do you have this morning?
I have Avery McKinney set for exam at 11. I will be there. I was just asking if Madam Prosecutor could send me the paper discovery. I only have an investigator's report. I don't have any police reports, but I am ready to go. I just was just asked if that's possible, if she could send me the police reports. I'd appreciate that.
All right, Ms. Bailey, can you do that? All right, she's gonna do that.
Thank you.
Mr. Deeble?
Yes, ma'am. Just plans,
Oh.
then it would adjourn from the 23rd today. Phone number, and then it would just on the order after the meeting.
Kenyetta is there in the last sentence, so one is in your office, one is.
Your Honor, I unfortunately don't have an answer to that. My supervisor should be downstairs. So if you have asked Waldman.
Good morning, Mr. Slesky.
Morning, Judge.
You're here on Robert Hudson.
That's right.
Okay, we're waiting for Miss Irvin. I haven't seen her this morning.
Okay.
All right, thanks.
Yep, exactly. Oh, thank you. Oh, you're welcome.
Whatever you say.
Brown,
Good morning, Judge. Sorry about that.
this is the people of the state of Michigan versus Ryan Kimmons, case number 22 S55438. Mr. Kimmons is charged in count 1 with weapons carrying concealed, count 2 police officer assaulting, resisting, or obstructing, count 3 weapons, felony, firearm. You have your appearances.
Your Honor, Jim Bailey on behalf of the people, P84009.
Good morning, Your Honor. May it please the court. Mark Brown, my P number is 39562, appearing on behalf of Mr. Ryan Kimmons. We waive any objection to continuing via Zoom. Mr. Kimmons, please unmute yourself and state your name for the record.
I'm sorry, Mr. Kimmons is not in custody. I don't know where Mr. Kimmons is. He's not in my waiting room either.
No, he isn't in custody. I'm sorry. I thought he was already there, Judge. I apologize. I can waive his presence. I have had contact with him.
Okay, thank you. Court will waive Mr. Kimmons' presence for today's probable cause conference. Mr. Brown, have you received discovery in this case?
I'm not aware of receiving it. I said that earlier, and someone said I sent it to you on Friday. So if it's been sent, it's great, but I'm not aware of receiving it.
It has been sent.
Oh, all right, so just make sure that you have it and notify the prosecutor if you don't before a week from today, which is the 28th. I will schedule this for an in-person preliminary examination. When did I schedule your other case? Oh.
The 11th.
So let's do it April 11th at 10 a.m.
At 10, Judge?
Yes, same time.
Okay, thank you very much.
All right, so we'll see you and Mr. Kimmons on that day and time.
Thank you. Thank you, Ms. Sanford, also. Thank you.
Morning, gentlemen.
Morning, calling Matthew Mercer. I apologize.
That's okay. You need to speak with Mr. Mercer?
Yes.
All right, I'll place you in recall.
Okay, thank you.
I don't understand how we don't. Morning, Your Honor. But not.
They can take us until 10:30, so it's down to 10:30. Oh, no, they go down to 10:30.
Yes, Your Honor. Trying to wait to do all the cases. Actually, just let the circuit court know that.
I'm calling you. If they go there, we found me saying, I'm having this hand.
right, let's do a vote. This is the people of the state of Michigan versus George Polk. Case number 21 F60623. Mr. Polk is charged in count 1 with weapons carrying concealed. May I have your appearances, please?
Good morning, Your Honor. Irvin, on behalf of the people of 84009.
Good morning, Neighborhood Defender Service by Kate Demont Grady, 83667, on behalf of Mr. Cope, who's with us in the courtroom. Mr. Cope, please state your name.
Morning, sir. Good morning. Today's the date and time set for a preliminary examination of the parties ready to proceed.
Who's ready?
All right, any preliminary matters?
Just ask for a mutual order of sequestration.
Thank you. Court will order all witnesses sequestered with the exception for the officer in charge. Ms. Bailey, how many witnesses do you have?
Your Honor, one at most two. At this time, people would call Trooper Adams.
Sir, I need to provide a spelling of the name to the court.
Versus MKRK.
And can you please raise your right hand? Do you swear or affirm that the testimony you provide will be the truth? Please watch your step, watch that forward. You're gonna have seats on that chair. There is a microphone that is right across from you. Right, facing that microphone, along with hold the microphone. And just a moment. Are you ready, Mr. Shulman?
Yes, Judge, we're just setting it for exam.
Okay, this is the people of the state of Michigan versus Matthew Mercer. Case number 22 F56295. Mr. Mercer is charged in count 1 with assault with intent to murder, count 2 assault with intent to do great bodily harm less than murder or by strangulation, count 3 assault with a dangerous weapon, and counts 4, 5, and 6 weapons felony firearm. May I have your appearance, please?
Morning, Your Honor. Irvin Bailey on behalf of people, P84009.
Good morning, Your Honor. Sanford Schulman, excuse me, P43230, appearing on behalf of Matthew Mercer, who's appearing by way of video conferencing from the county jail. He consents to that.
All right, Mr. Mercer, state your name, sir.
My name is Matthew Mercer.
All right, good morning, Mr. Mercer.
Good morning, Your Honor. My name is Matthew Mercer.
All right, thank you. Today's the date and time set for a probable cause conference. Mr. Shulman, please go.
Your Honor, I've spoken to Mr. Mercer. I received the discovery this morning. He's demanding an exam in person. So whatever's earliest possible date. He's been working apparently at the Detroit Water and Sewer for over 25 years, no prior record, hopes that we can address these issues at the earliest date.
Thank you. The court can schedule this for an in-person preliminary examination on, hold on 1 second.
Yeah.
I have availability, but he's in custody, so he won't be here. I can do it at 10 o'clock on March 29th.
That works for me.
All right, so then we'll conduct the preliminary examination on 10 o'clock on March 29th.
Okay, great. We'll see you then. Thank you.
Thanks.
That's in person?
Yes, sir.
All right. Thank you.
All right, right, so we're back on the record in the matter of Doris Hope. Officer, if you can just hold that microphone and speak loudly and clearly to the mic.
Yes, sir.
All right, thank you. Your witness.
Thank you, Your Honor. Could you please restate your name for the record?
Mark Adams,
And where are you currently employed?
Michigan State Police, Metro South Post,
How long have you been employed by the Michigan State Police?
5.5 years.
Were you employed by them on September 1st, 2021?
Yes, I was.
Did you work on that day?
I did,
Were you by yourself or with a partner?
with a partner,
And what was your partner's name?
Trooper Renee Mejia,
Could you please spell Trooper Mejia's name?
first R-E-N-E, last of M-E-J-I-A.
And were you on foot or in a scout car?
And a scout car,
Was it fully or semi-marked?
fully marked.
What does it look like?
It's a black car with a red bubble on top, with emergency lights all around the vehicle. That Michigan State Police marked on the car,
And were you in full or modified uniform?
fully uniformed.
Is that similar to what you have on today?
Yes, ma'am.
So it's full blue uniform with your patches, badge, and other things necessary for your employment.
Correct.
Did your duties as a Michigan State Trooper take you to I-94 in Van Dyke?
Yes, it did.
Is that here in the city of Detroit,
Yes,
county of Wayne?
yes.
What if anything brought you to that location?
We were dispatched to that location for a report of blocking crash. Blocking a lane of the expressway.
And what, if anything, did you observe when you arrived at the scene?
Arrived on scene and observed a silver Dodge Stratus abandoned in the blocking lane of the freeway.
Now, when you say abandoned, what do you mean by that?
There was no occupants in the vehicle at the time of arrival.
What, if anything, did you do next?
We called our dispatch and ordered a
Just a week. All right, Officer Adams, if you can just tell us what you do.
I ordered a tow truck through our dispatch, so the vehicle could be towed and removed.
And what, if anything, else did you do prior to the car being towed?
It conducted an inventory search on the vehicle.
And what, if anything, did this inventory search yield?
When I went to the vehicle, I observed in plain view a black pistol on the floorboard passenger side of the vehicle.
So I'm gonna stop you right there. So when you say the passenger side of the vehicle and it was on the floorboard, do you mean the front passenger or the rear passenger?
Front passenger.
What, if anything, did you do next?
I secured the firearm and I continued my search.
Did your search yield anything else?
Yes, I found a magazine with ammunition in it in the front passenger glove box.
What, if anything, did you do next?
We secured the firearm and the ammunition in the magazine. The vehicle was removed from the freeway and Trooper Owens conducted a TLO search. Well, first we ran the license plate of the vehicle, or I ran the license plate of the vehicle.
And did the license plate provide you with any information?
It did.
What did it provide you?
The registered owner,
And who is the registered owner?
area scope.
Objection, hearsay.
Well, Your Honor, it's not hearsay, it's a reliable database that this officer uses regularly to conduct search.
All right, hold on.
I'm sorry, could you please restate that?
I ran the license plate and received information saying the registered owner of the vehicle was Darius Gold, who was provided an address.
And when you were given the name Doris Hope, was a photograph also brought up?
I can't recall if we brought a photograph up at that point.
What, if anything, did you do with this information then?
We took the information and then it was ran.
Just a week. All
Sorry.
right, but wait a minute. So. Okay, tell us what you do.
I took
If
the,
you did it together with your partner, then he can testify to what he did with his partner.
Understood. There's things that I've been wondering, I'm like, do I cross on that? Because
Right.
she did it exactly, or because we did it as in he would.
Right,
So
so-
just so we can be clear, like my partner and I would help me.
my apologies,
Okay,
I'll clarify.
go ahead.
I took that information and I contacted Trooper Owens. Trooper Owens ran the registered owner's information through a database called TLO, which we were provided, or I'm sorry, which I was provided with by Trooper Owens.
Objection as to hearsay.
Your Honor, it's not being offered for the truth of the matter asserted, just for the effect of the listener and what he intends.
All right, so I didn't hear the hearsay yet. It may be Tony.
So you were provided with information by Trooper Owens. What, if anything, did you do with that information?
I was provided with an address and then my partner and I, Trooper Media, drove to that address.
And when you arrived at that address, what, if anything, did you observe?
Myself and Trooper Media made contact with the ex-girlfriend of the registered owner of the car, Doris Hope.
And did you make contact with the registered owner?
I did, or not the registered owner of the vehicle.
Did you make contact?
I'd have to reference my report with the full name. I know it was a Mrs. Dunn.
Would that refresh your recollection as to the full name?
Yes, it would.
I'll stipulate that it was his Octavia Dunn.
Okay, thank you.
So what, if anything, did you do after interacting with Ms. Dunn?
I asked her if she knew Doris Hope. She said yes.
Objection hearsay.
Not being offered for the truth of the matter, just for what he did.
I've been asking, what did you do after sustained? So after you conversed with Ms. Dunn, did you receive some information?
Yes.
What did you do with the information?
I was provided that Doris Hope was walking at Mound and McNichols on foot.
And what did you do with that information?
I notified Trooper Owens of the location of Doris Hope, and they then made that location.
Did you ever make that location?
I did.
And when you made that location, I believe you said Mound?
Mound and McNichols.
Thank you. What, if anything, did you observe?
Trooper Owens had Doris Hope detained at that time.
How do you know it was Doris Hope?
They had, Trooper Owens had advised me that that was the suspect.
Do you see the person that Trooper Owens had detained here in the courtroom?
Yes,
Could you please point to him and tell me something he's wearing?
gentleman over there wearing a black hoodie.
And did you have occasion to speak, Your Honor, let the record reflect that the witness identified the defendant. Your Honor, I'm sorry. Did you have occasion to speak with this individual at all?
I did.
And when did you speak with him?
While he was in my patrol car.
Do you know if he had been provided his Miranda warnings at that time?
Yes, I provided it.
And did he indicate to you that he understood all of his Miranda warnings?
He did.
And what, if anything, how long was he in the back of your scout car?
He was in the front of my scout car, in the front passenger seat. From the time of arrest to lodging, approximately an hour.
An hour? And did he seem to understand his rights as private inmate?
Yes,
What, if anything? Strike that. Did he waive his rights and speak with you?
Yes.
Your Honor, at this time, I'm going to turn the witness over for voir dire as to the voluntariness of the statement.
Thank you. Mrs. Demond.
Thank you, Your Honor. Mr. Brown, you had Mr. Cope, you said in your scout car, correct?
Yes.
And you had him in the front seat or back seat?
Front seat.
And you said you read him his Miranda warnings?
Yes.
And did you have him sign a form, a Miranda form?
No.
Did you have him, so did you read each question to him individually, or did you have him read a card?
Well, I read it off the department issued form, so the 52, it's the warnings card.
And in your scout car is equipped with audio and video recording, correct?
Yes.
And it's MSP policy that you record a Miranda advisement, correct?
Yes.
So you would have turned that over to the prosecution, correct?
Yes.
Thank you.
Your Honor, I would just note my objection as to going outside the scopes of knowing a voluntary waiver of his Miranda rights as human into this conversation.
All right.
But it's too late at this point for the court to do anything about it, just note my objection. What, if anything, did the defendant say to you?
He stated that he was driving to a casino in Detroit and he was involved in a crash that had left his vehicle at westbound 94 Van Dyke, if anywhere found it. He confirmed his vehicle is a silver Dodge Stratus. He also confirmed that he had his firearm in the vehicle. He said it was under the front passenger seat at the time. He said he carries the firearm for protection because it's in Detroit.
And do you know if the defendant has a concealed pistol license?
He does not.
How do you know that?
Prior to making the address initially that we talked about before, I had our dispatch run his CPL status, and we discovered that there was no CPL status.
Did you inquire with the defendant as to the CPL status?
I did.
And what was his response?
He stated that he did not have one, and he had knowledge that you did in fact need a CPL in the state of Michigan to carry.
No further questions.
Cross-examination.
So, Trooper Adams, you never saw Mr. Cope in that car, correct?
Correct.
And you never saw anyone in that car?
Correct.
And you did not see the location of the gun prior to the crash?
Can you ask that again?
The location of the gun, you would not have seen that prior to the crash?
Correct.
And you said that you inventoried the car. Did you fill out an inventory form?
Yes.
And did you provide that to the prosecution?
That document doesn't go with our warrant request packet to the prosecution. It's just an internal department form.
Nothing further. Thank you.
Any redirect?
The handgun, where did you find it again?
It was in plain view, sitting on the front passenger side floorboard of the vehicle.
Did you locate any lock boxes?
No,
Anything to secure the weapon?
no,
And is either under the seat, as told you by the defendant, or on top of the seat, the proper way to transport a handgun?
no.
No further questions.
Thank you for Brad.
Thank you.
Are there any other witnesses on behalf of the defense?
No further witnesses.
Any witnesses on behalf of the defense?
No, Your Honor.
Ms. Green.
Honor, at this time, we will move for over. Trooper Adams testified that he and his partner responded to I-94 in Van Dyke during the Frank County of Wayne to a crash scene where they located an abandoned vehicle, Your Honor. Upon further investigation, they located a handgun and a magazine. The handgun was not properly transported, being on top of the seat, and as later testified to by the trooper, the defendant told him that it was in fact under the passenger seat, Your Honor, as which is a proper way to transport a firearm without a CPL license, which the defendant does not have, per lien and also per his admission. Additionally, Your Honor, based on some further investigation done by officers, the defendant was located at Mound and McNichols, also here in the city of Detroit, County of Plain, where he was detained for the crash, abandonment of his vehicle, as well as I believe the weapon. He was Mirandized, he did voluntarily waive his Miranda and admitted to Trooper Adams that he wasn't the driver of this vehicle, he got into a car crash at the location, and it was his gun in the vehicle at the time of the crash. Your Honor, therefore, people have by probable cause standard and this court.
Thank you. Defense object to that argument. All right, thank you. The court, having heard the testimony from Trooper Adams, believes that the prosecution has been by probable cause standard, and the defendant will be bound over to the Third Circuit Court for arraignment on the information. He'll be arraigned 2 weeks from today, which is April 4th at 9 a.m. Thank you. Thank you. You're welcome. Good morning, Ms. Belcher.
Good morning, Your Honor. How are you?
Good. You were called in on the Hudson matter? I will call that case. Mr. Slesky, are you ready?
Yes, Judge.
Okay. This is the people of the state of Michigan versus Robert Hudson. Case number 22 F55654. Mr. Hudson is charged in count 2 with stolen property, receiving and concealing motor vehicle. And he's placed on notice that he's a habitual offender. Or may have your hearing.
Good morning, Judge. Jacob Slusky on behalf of the people, P83677.
Good morning, Your Honor. May it please the court, Leanna Belcher, P80177 on behalf of Mr. Hudson. Your Honor, I was just spot assigned. I don't know if that's Mr. Hudson in the JCF hearing room.
No, that's not him, and he's not in my waiting room. The court will waive Mr. Hudson's presence for today's probable cause conference. Ms. Belcher was recently appointed, just now appointed to this case, and the court is going to order that discovery be provided to her no later than a week from today, which is the 28th of March. Ms. Belcher, we'll come back next week, Monday, to see if you're able to contact your client. You may contact him. And you are then I'll schedule the exam next month. I'll schedule it on next week, not for next Monday, but.
Thank you, Your Honor. And once I get the discovery from Mr. Slusky, I should be able to use that to get an investigator involved so that they can locate Mr. Hudson.
Okay, Judge, I just want to make sure we have this set for PCC on Monday next week.
Yeah, but now that I say that out loud, I'm thinking maybe I should just give a couple weeks to allow her an opportunity to look at the client. So,
Okay.
adjourn the PCC, we'll come back on the 4th of April at 8:38.
Okay, so no date next week, Monday?
Nope, just make sure she has discovery.
Okay, I'll send that today.
Thank you.
And Ms. Belcher, if you locate your client, please make sure that he appears over Zoom on the 4th of April.
Of course.
Thank you.
Thank you, Your Honor. I hope you have a great day.
Thank you.
Thanks, everybody.
Good morning, Mr. Shaw. We're waiting for your lawyer.
Any update on Sean and State?
Your Honor, I sent my supervisor a text message. I'm now sending email. Okay. I also did make a phone call and we sent that.
Yeah, so it's come up. I see. Hi. How you doing? Good.
You have witnesses here. Marlon, Red. Last name check.
That count.
Oh, yeah. Well, I'm gonna hold it, hold your hand, do it this way. Try not to, but, all this stuff about sharing, and the money, hot water, none of that has anything to do with it. Probably is, it's not actually what it is, what it is. Here, has nothing to do with anything, like I'm trying to tell you. All in here today, see if they can get. Their police officer. All of that is. We're gonna get off the rule. I cannot do that. But you're wrong. Preliminary exam, main trial, legal trial, they're approved to have before that. They don't have to do it. All I gotta do is find it, and you like to do it. They're gonna be the same as the one.
Okay, thank you, Watson.
Ready on, you can bring on. Okay.
Your Honor, you might have to walk over there and get a drink.
No, go ahead.
Hold on.
This is the people of the state of Michigan versus Latoya Marlon Gretton. Case number 22 F55690. Ms. Gretton is charged in count 1 with police officer assaulting, resisting, obstructing. Count 2 is a misdemeanor. She placed on notice that she's a federal offender 4. May I have your appearances?
Good morning, Your Honor. Brenda Bailey on behalf of people P84009.
Ronald Devo, P63897. On behalf of Miss Marion Bratton, who's behind me on my left. Please state your name.
Good morning.
Good morning, Your Honor.
Today's the date and time set for a preliminary examination. Are the parties ready to proceed?
Your Honor, at this time, people are not prepared to proceed. Officer Gursky was subpoenaed today and he has not appeared. Reminder emails were sent. I would just ask the court is inclined to grant defense's motion that it only be took out 1 as opposed to a misdemeanor and it was not intended to prove that day. And it is a separate witness who is not to be.
Thank you. Mr.
I object. I ask the one that reads this.
All right, thank you. So the court is going to dismiss the felony count that was scheduled today. The court will, however, schedule the misdemeanor count for a pre-trial in front of Judge Bryant on April 11 at 9 a.m.
Okay. If it's okay with the court, I'd like to speak with my client. Kind of private.
I mean, if it's okay with the court.
That okay with you?
You gotta go downstairs. I got one coming up now.
Oh,
You go
well,
downstairs.
I'm gonna have a quick conversation with him right now, if nothing. Okay. no, it's gone. Well,
Work this way, man.
You have a moment to address the bookkeeping issue, or record keeping issue? Well, this was originally scheduled for the 10th, and I was prepared to proceed. And I objected to it being adjourned, the possibility that I could get that on the register of actions, that it wasn't adjourned on my account, possibly I could get paid for it.
So I do have an email here where the prosecution asked that the matter be adjourned because the officers were on furlough.
Right, I understand that.
Right, no, I get what you're saying. I'm just kind of making the reference.
Oh, I'm sorry.
Yes. So it will, the register of actions will know that it was the prosecution's.
Thank you very much, Your Honor.
You're welcome.
Okay. All right, everybody, have a good day.
Thank you too.
Oh, okay. I mean, it works now because we're not on the record.
I can't walk around. It's right there. I'm going to look at what was the extra thing.
Any update from your supervisors?
You stand how all the time. Good.
McKinney. This is the people of the state of Michigan versus Avery McKinney, case number 21 F61397. Mr. McKinney charged in count 1 with weapons carried concealed. May I have your appearances, please?
Your Honor, good morning. May it please the court. My name is Adam Clements, P number 77233, appearing on behalf of Mr. McKinney. Sir, state your name for the record, please.
All right, good morning, sir. Today is the date and time set for a preliminary examination. The card is ready.
Yes, Your Honor.
Okay, the court is going to order all witnesses sequestered. There will be an exception for the officer in charge
Ms. Bailey, how many witnesses?
One, Your Honor. It's time to call Officer Bailey Rumsfeld.
Sir, can you please raise your right hand? Do you swear or affirm that the testimony you will provide? Yes. Have a seat in that black chair. Also, please grab the microphone that's right across from you. The entire patient. Hold it, speak loudly.
Can you please restate your name for the record?
Daily Rumsfeld?
And are you currently employed?
Yes.
Where are you currently employed?
The Detroit Police Department,
How long have you been employed by the Detroit Police Department?
going on 5 years,
And in what capacity are you employed?
police officer.
And were you working as a police officer on October 8th, 2021?
Yes.
You work on that day?
Yes.
Were you by yourself or with a partner?
I was with the partner,
What's your partner's name?
Officer Patterson.
Could you please spell Patterson for me?
PATTRSO.
And were you on foot or in a scout car? A fully marked scout car?
Yeah.
And were you driving or in the passenger seat?
I believe I was driving, but
Would that refresh your recollection? Let the record reflect that I am showing Mr. Clemens, Officer Rumsfeld's report. Permission to approach. Please review your report silently and let us know when you're done.
Okay.
Did that refresh your recollection?
Yes,
Were you driving or something else?
I was driving.
Did your duty as a Detroit police officer take you to Barlow and Collingham?
Yes.
Is that here in the city of Detroit,
Yes, but,
county of Wayne?
Yes.
What if anything brought you to that location?
to the vehicle part blocking the driveway with illegal permit.
And what if anything did you do in response?
I initiated my own red lights and approached the driver's side of the vehicle.
And when you approached the driver's side of the vehicle, what if anything happened next?
So the driver, my reason for stopping, asked for a license, registration, insurance, driving license, but expired registration and insurance. While talking to him, I observed any crime marks around. There's a box where you turn your lights on and off next to the steering wheel.
Okay.
And that Impala. was a common sketch file for what we're trying to do.
So, how many people were in the vehicle?
Just,
And you see the sole occupant of the vehicle here in court today?
yes,
Could you please point to him and tell me something he's wearing?
she's wearing a black shirt with black pants.
You're gonna let the record reflect that the witness is identified the defendant. So after observing these crime marks, what if any, or suspected crime marks, what if anything did you do next?
Asked him, to check the vehicle for weapons. Said no again, calling his, anxiously.
He said what?
He said no.
What if anything did you do next?
Had next to the vehicle, there's no insurance or, registration. I'm sorry, it was expired insurance registration. Conducted inventory search of the vehicle prior to the stop.
And what if anything did you recover from the inventory search?
I recovered a can gun out of that, light box that I previously noticed there was fire marks around.
And so was the light box open?
It was loose.
Just, describe loose for me. What do you mean by that?
So if the box had not been tampered with, it would have been difficult to remove. However, it was loose and it came out very easily.
Objecting to the lack of foundation.
The same foundation. Have you encountered many cars of this make and model in your time as a police officer?
Yes.
And have you encountered light boxes that have you suspected to be tampered with and you have not suspected to be tampered with?
Yes.
And what difference have you noted during those, between those two?
Light box tampered with a lot of times have primers from say a screwdriver or a knife around the edge, or very loose because of the clips of the box.
And in the defendant's, in the car that the defendant was in, which did you observe?
The primers were around the edge of the box, and the box was loose.
What, if anything, did you locate?
I located a firearm inside that compartment behind the light box.
Was the firearm loaded?
Yes.
What was it loaded with? Yes. Does that refer to recollection?
Yeah.
What, if anything, was it loaded with?
It was one of the 15 9mm cartridges.
Were they live?
Yes.
What, if anything, did you do once you located the handgun?
I notified my partners my discovery of the radio and placed Mr. McKinney under arrest. Shoot on the CPR.
How do you know that?
Based off his age. Yeah, you're showing one of the investigation.
And what, if anything, did you do with the handgun after locating it?
I placed it on evidence.
And did you conduct any further investigation as to the weapon after making it safe?
We always check the serial number through our lean system.
Did you do that?
Yes.
And what, if anything, did you?
Yeah.
Would that refresh your recollection?
Yes.
Please do so. What did the search, did that refresh your recollection?
Yes.
What, if anything, did running the serial number of the firearm reveal to you?
That the firearm was under.
What, if anything, did you learn about the car that you found the defendant in?
The vehicle was registered.
Thank you. I have no further questions at this time.
All right, cross-examination.
Good morning, officer.
Good morning, sir.
Officer, my name is Adam Kimmons. I'm going to ask you some questions on behalf of Mr. McKinney. If I ask you some questions you don't understand or speak too fast, just let me know and I'll try to ask you a better question, all right?
Sounds good.
Okay. Now, on the day in question, you were working on routine patrol, is that correct?
Yes.
Okay. And you were accompanied with several other officers, were you not?
Yes.
Okay. Now, you had indicated, well, let me ask you, you authored that police report that sister council provided to you, correct?
Correct.
Okay, and you did your best to make sure the information in that police report was true and accurate, right?
Yes.
Okay. Now, you said that this vehicle came to your attention for what reason?
It was parked blocking the driveway and had illegal nothing.
Okay. Now, this vehicle was parked at this particular time, was it not?
Yes, parked it.
Okay. You're sure that the vehicle was running?
Yes.
What allows you to be certain about that?
Running lights and exhaust.
Okay. Of course, those excluded, Your Honor. You were equipped with a body cam on that particular day, correct?
Yeah.
this your name in the lower left-hand corner?
Yes.
Okay. Does that appear to be a fair and accurate description of what you recall as it relates to your investigation on this particular day? You need to see more. That's what I. Okay, at this time, Judge, I'll move for the admission of the defense exhibit A. Now, you just testified on direct examination that you saw running lights and exhausts, correct?
Initially, yes.
Okay, you'd agree at this particular.
Your Honor, I actually objected that as an incorrect statement of his testimony. He testified that the car was parked and had illegal window tint on direct. It was not until cross-examination and testified as to the length and the exhaust.
So I guess her objection is that, did your question say it was on direct that he testified that?
I say you just testified.
I heard on direct.
Well, you just testified that it had running lights on and exhaust, correct?
Yeah.
Okay, but you agree that as you're approaching the vehicle, there's no running lights on, right?
I can't tell.
Okay, let's look at it. Let's look at it from the.
For the record, counsel stopped the video at 19 seconds. Yes, Your Honor. But the record reflects that counsel stopped the video at 19 seconds.
You agree after looking at that, there's no running lights on, is that correct?
I can't tell the headlights from my view.
Okay.
From the video.
Let me approach with my laptop and see if this helps you testify more truthfully about whether or not they're. Are you able to better see it when you're looking at my laptop? Yes. There's no headlights, on, right? Right, but they weren't on at all. I'm talking about this is when you immediately got out, and there are no headlights on, right?
When I immediately got out.
Right. Now on top of that, you didn't. I mean, it's a looser back. I know that I had beard. You didn't affect your overhead lights, correct? Excuse me?
I normally do, but I had.
You didn't do it in this particular case, right?
I guess not.
And because you didn't affect your overhead lights, we don't have any dash cam to show the rear of the vehicle, correct? To actually look at the exhaust.
It should have been done when I hit my. Should have, whether it did or not, I mean, it's system.
And ultimately, there was never a point in time where you directed Mr. McKinney to turn the vehicle on, correct?
Not that I recall.
Okay. Do you want to see it? Because I want to make sure that we're all on the same page about whether or not this vehicle is on. So do you want to look at it to see what you're directed to turn the vehicle off?
No.
In fact, you never gave that direction, right?
I don't recall.
Okay. So in this particular case, when you had an opportunity to approach this vehicle, you asked this individual for license, registration, and proof of insurance, correct?
Correct.
You never saw this vehicle actually moving, right?
No.
You never saw this vehicle actually driving, correct?
Correct.
So when you said that you were investigating a potential infraction, you're talking about a parking violation, right?
Correct.
So when we talk about tinted windows, it doesn't matter if the windows are tinted if the vehicle is parked, correct?
Public street.
Nonetheless, so are you telling me that you can issue a citation to a parked vehicle on a public street that has tinted windows? That's not moving?
It's occupied with the driver, the driver's license, the issue.
But also, you'd agree that the law prohibits an individual from driving a motor vehicle with tinted windows,
I'm going
correct?
to object as to the conclusion of the legal fact as well as he testified as to what he saw and what he did. So your response?
I'm not sure what the objection is, Judge. The officer testified that he initiated an investigation for tinted windows.
So I think that the officer can testify as to whether or not there was some violation of the law. And I think that's what this question is asking.
The vehicle was parked. I mean, the vehicle's parked, right?
Correct.
Okay. So when we're talking about tinted windows, that's for individuals that are driving motor vehicles with tinted windows, right?
No, the exact verbiage of the ordinance.
Well, let me ask you this. Did you issue a citation for tinted windows?
Yeah.
You did? I'm gonna ask you to take a look at your police report and see if you did, what ticket number was that was provided.
Ticket number all 1259443.
So if to be fair, if you don't know whether or not the citation applies to vehicles that are being driven or vehicles that are parked, how can you use good faith issue a citation?
I know the citation refers to windows and seats, storage, and the top of the window.
But you're uncertain about whether or not it applies to vehicles that are parked or vehicles that are being driven, right?
Specifically, no.
You agree that that would be an important distinction, do you not? What's your target focus while you're on the street? Are you a special operations officer?
Yes.
Okay, so what is your target focus while you're on patrol?
The big, narcotics and weapons.
But in this particular case, what drew your attention to this vehicle is that this vehicle is parked in the property, correct?
Correct.
How many parking citations have you issued in the last year?
Objection, Your Honor, relevance.
Do you regularly and normally issue parking citations?
I regularly investigate parking violations.
Nonetheless, I'm asking you, do you regularly issue parking citations?
Objection, Your Honor, relevance.
So as it relates to Mr. McKinney, well, also, I asked you if the information in your report was true or not. Did you follow that question, correct?
Correct.
You indicated in your police report that you drove past this vehicle, do you not? Take a look at it, please, that will refresh your recollection.
Did not.
I'm sorry, what was your answer?
I did not indicate that I drove past it.
Were you working with Officer Patterson as well on that particular day?
Yes.
Yeah, these reports are one hearsay, Your Honor.
What are you objecting?
Well, you had it shared on the screen. That was my objection.
All right, so he was taking it down. You know the rule.
So ultimately, you directed Mr. McKinney to exit the vehicle, is that correct?
Correct.
Okay, and then you told him that the Supreme Court gives you the authority to conduct a traffic stop with the passenger, with the driver either in the vehicle or outside the vehicle, correct?
Correct.
Okay, and the reason that you were detaining Mr. McKinney at a particular time that you engaged with him was for a parking violation, right?
I haven't stepped out of the vehicle, there is no insurance in the registration.
Okay,
Expired. Expired registration.
a parked vehicle regarding no insurance and no restriction, right?
Correct.
Then, you ultimately asked Mr. McKinney for permission to search his vehicle, he told you no, right?
Correct.
And you'd agree that despite the fact that he didn't give his consent, your partners began to open his door anyway, is that correct? Okay, I'm gonna ask you to take a look at this and see if it helps with fresh recollection. Well, let me ask you, you were at the vehicle, right?
Yes.
Okay, and you recall specifically, you testified on direct examination that you asked for permission and Mr. McKinney told you no and asked to call his mother, correct?
Correct.
The record reflect that council started the video then at 1:56.
Well, actually, it's not, and Mr. Clemens, if you can make your record as to where you started the video.
Sure.
Are you getting audio? I mean, audio.
I don't think you shared it.
Indicating for the record, that I'm gonna start playing the video at 2 minutes and 5 seconds into the video.
I told you I was just dropping them off.
I understand that.
You gonna just look through the car. Come on, man.
I didn't look in the car. I had to step out.
My window, look, my door is open. Why is my door open if you ain't looking in the car?
Ain't nobody looked in your car.
Can you close my door, sir?
He couldn't see in the back.
You agree that your partner, Officer Lee, is already opening my client's door beginning to conduct the search. Would you agree?
Opening the door and conducting the search.
Okay, but nonetheless, you need permission at this particular point in time to do so, correct?
So see through illegal windows.
Well, to open the, well, let me ask you, you said that the front windows were illegally tinted. Did you not when they testify in direct examination?
Yes.
Okay, but Officer Lenny is opening the back door, right?
I think it was already open. From here. Did you open the back door or is it the passage?
What? I mean, would you need to move forward to the TV or I can bring the laptop? I mean, he's clearly not standing at the front door.
Your Honor, my objection is argument. Mr. Clemens can ask questions and the officer can respond to them. It's not a back and forth argument as to what he sees. This officer has testified, I can't tell which door you have.
Excuse me.
Okay, what can I provide for you to help you testify as to what your partner is?
Can I see the laptop closer to me?
Sir. For the record, I'm gonna rewind the video back to 2 minutes, 10 seconds. Let the officer play.
I didn't look in the car. I had to step out.
My window, look, my door is open. Why is my door open if you all ain't looking in the car?
Ain't nobody looked in your car?
Can you close my door, sir?
He couldn't see in the back seat. The car?
And in fact, you even say he couldn't see in the back seat, correct?
Correct.
So you'd agree he's opening the back door, right?
Correct.
Okay, at that particular time, McKinney didn't give his consent, correct?
Correct.
So you'd agree that he's opening the back door without permission to do so, right?
Correct.
Okay, and at the particular time, Mr. McKinney, it would be impossible for him to, from where he's standing there, at 2 minutes and 11 seconds into the video, it's impossible for him to grab anything in the back seat in position to where he's standing without getting back in the car, right?
Correct.
So there's nothing in his grab area there, right?
Correct.
You can see both of his hands, correct?
Yes.
So there's no concerns for officer safety, right?
Right.
Okay, and at this particular time, you didn't have any suspicions regarding officer safety, correct? Okay, because from this particular point on, you then go back into your vehicle, correct, and you get to have conversations with another one of your partners. Is that correct?
Right.
Okay, and at no point did you place Mr. McKinney in handcuffs prior to going into your scalp, correct? Okay, and you recognize that you have the ability to do so if you have concerns about officer safety or things of that nature, or if an individual is uncooperative. Would that be fair to say?
Correct.
And you didn't do that in this particular case, right?
He was walking.
Okay. Then you would agree that once you got back into your squad car, you specifically made the decision to impound the motor vehicle. Is that correct?
Correct.
Okay. Now, when you impounded the vehicle, you conducted inventory search subsequent to that. Is that correct?
Yes.
Okay. And when you conduct that inventory search, you're looking for valuables specifically for tabulation and safety, correct?
Valuables and dangerous.
Okay. But what I'm saying to you is the particular area that you testified that you searched, that's an area that you testified that you have experience with contraband. Is that correct?
Correct. Contraband is dangerous items such as fentanyl or guns or other drugs.
Now, you would agree that you needed to use physical force in order to pull that area out. Is that correct?
It was loose.
Nonetheless, you still had to use force to pull it out, correct?
What's your definition?
Okay, well, let me just ask you, did you have to grab the light component, the light fixture?
Yes.
Did you have to physically grasp it and you can apply force in order to remove it?
Much like a door handle or other object. Yeah.
In the absence of you doing so, it would not have moved, correct?
Correct.
So when you went back to conduct the inventory search, you immediately went to the light area. Is that correct?
Correct.
Okay. And at that particular time, you're doing so because you wanted to investigate what was in it, correct?
Correct.
What, if anything, is in it, correct?
Correct.
At the time that you did so, was Mr. McKinney under arrest?
Thank
Was he under arrest?
No.
Did you notify him that he was under arrest?
Not that I recall.
And he still wasn't placed in handcuffs, correct?
Correct.
You also, when you conducted this search of the vehicle, you moved him to the front of your scalp. Is that correct?
Yeah.
Person doesn't show. I'd ask you, officer, to take a look at turn your attention to end it playing for the record at 5 minutes and 7 seconds into the.
93.
Stop it in 5 minutes and 27 seconds into the video. You agree with your body cam reflections, you're physically pulling that light assembly out, is that correct? Yeah. And that's ultimately when you recover the firearm, is that correct? Yeah. Now, you agree with me that when you're conducting an inventory search specifically, the Detroit Police Department has specific policies and procedures that you're to follow when you conduct an inventory search, is that correct? Correct. Per Detroit Police Department policy, you're allowed to search compartments, correct? Correct. You're allowed to search containers and things of that sort, correct? Correct. Is there anywhere in the policy that you can point me to where it allows you, per policy, to disassemble a portion of the vehicle to search that particular area? But you would agree that you physically remove that cover in order to search that area, correct? Because I observed it and tampered with. Nonetheless, it was still as a part of an inventory search, correct? Correct. Thank you, Judge. Nothing further.
Any redirect? All right, Officer Wunschlag, I have a couple questions to ask of you.
Yes.
You indicated that you were able to get a valid driver's license from Mr. McKinney.
Yes.
And you also testified that you were provided with an expired insurance and expired registration.
Yes.
All right. Is there a difference as it relates to expired insurance and no insurance?
No.
Any questions based on the first questions? No, Your Honor.
Yes, Your Honor, I do have one question. Did Mr. McKinney provide you with a 2021 registration?
It was,
Right, but then you corresponded with him and you specifically asked him, do you have a 21 registration, and he handed it to you, is that correct? Of course, he does, Your Honor. Playing for the record at 50 seconds into the video.
At a tire company called the it's on the jacket back there. I work at a tire company though.
A tire company?
Yeah.
Oh, you make the tires or you put them on?
We make them.
Oh, okay. Is your registration expired?
No.
You hand me one from 2020 here.
No, my bad. It's shit, 2 of them in here, my bad. Let me see.
Was this plate good?
Yeah. That's the only one I got though, so.
Is the only one you got?
Yeah.
Oh, okay. You said there's no weapons in here?
No.
You mind my partner make sure real quick? Since we're all talking here, sitting here chatting?
Not really though. Can I call my mom? You feel me?
Call your mom?
Yeah.
Oh, okay.
I'm kind of.
The last registration that he handed you, that was a 21 registration, was it not?
I don't know. It sounded like I said, is this all you have? He said, yeah. So I don't know if it was 20 or 21. I know I only wrote it for health insurance, but I don't know if you're right. I would have checked my computer.
Well, let me ask you this.
Regardless.
Let me ask you this. You issued him a citation for no insurance, right? Correct. But you didn't issue him a citation for no registration, correct? Correct. Thank you, Judge. Nothing further.
All right. Thank you. Thank you, Officer.
Yes, sir. Thank you.
Are there any other witnesses on behalf of the people? Are there any witnesses on behalf of the defense?
No.
Okay. Ms. Bailey.
Judge, I think I'm gonna start with what's easy, is that I believe that, you know, I know the court has heard me make this argument before, and I'm becoming more and more attuned to making this argument with the officers as well, is that in this particular case, the officer cites a civil infraction, 2 of which he initiated his investigation, right? One of which certainly doesn't apply. You can't cite the tinted windows as for moving motor vehicles, right? So I believe that the court should disregard that altogether. But the second aspect, the second piece is as it relates to him saying that the vehicle was not registered, when he doesn't issue a ticket for no registration, we can argue back and forth about what's said on the exhibit regarding Mr. McKinney clearly hands him another registration card. And they go back and they run the information, and Judge, I disagree with the officer. Having no insurance and having expired insurance certainly is two different things. One, if the vehicle is registered in 2021, and this occurs in October 2021, how do you get a new registration without losing insurance? The two are entangled together. So that's my first point. And then my second point, my major issue with this case is something that we continue to litigate vigorously. Is these inventory searches that are used as a ruse to investigate. People versus Pool is very clear. You cannot use an inventory search for the express purpose to do investigations that you would like to do. Even if he says, you know what, I saw primarks in my training and experience, that's something that's a trigger for me. That alone would be probable cause for him to search the area, especially when the individual is one, not under arrest, which he can see. So how is he performing an inventory search of an individual's vehicle when there's been no arrest effectuated?
So I disagree. Well, answer this. Are you saying that a person has to be arrested in order to impound a vehicle?
No, I'm saying in tandem, Judge. He has to have the ability, one, to impound the vehicle. Because I submit to you that he doesn't have that vehicle. And or the individual was arrested, and this will be an impoundment pursuant to an arrest. So I guess that's my point. I didn't phrase that in the best
So
manner.
you're saying, so your point is that he didn't have lawful authority to impound the vehicle
Correct.
based on the fact that he says that there was no insurance on the vehicle. I know that the blockading or blocking the driveway is a civil infraction. And that's nothing that would require the police to impound the vehicle. But your argument is that the fact that this vehicle is on the street and it has no insurance is not enough for the police to impound that vehicle?
Absolutely.
Wow.
Now, it would be different if the homeowner contacted the police and said, hey, listen, this vehicle is blocking my driveway. I want it removed. We don't have that vehicle. It would be, and then two, I submit to you, does it, and the body cam is an admitted exhibit. If you look at where this Impala is parked, I'd also submit to you that it's not obstructing the driveway either. You can issue a citation.
So I'm beyond that, like
Right.
the blocking of the driveway. My issue is, and what I need you to articulate clearly for me is whether or not these officers can allow this vehicle to remain on the road when there's no insurance on it.
So I guess, Judge, if he was driving, I'd have no argument. If he was moving the motor vehicle, I'd have no argument. If the vehicle wasn't parked, I'd have no argument. It's a parked vehicle. They don't know what he's doing there. He could have been calling for a tow. Someone could have come and towed the vehicle. All those things above. We don't know any of that. He just made the assumption that he drove there, that he was driving. In fact, I would submit to the court that his initial testimony was disingenuous to the extent that he articulated that the vehicle was on and running. Why? Because per his training experience, and most police officers, they attenuate that to operating motor vehicle. The vehicle was off. It's parked. So it's no different, Judge, than if I have a car that I'm not driving right now, and I put it in front of my house, and it's parked there. And whether it's positioned in a manner that obstructs part of my driveway or some of the driveway, I'm not required to leave insurance on it while it's parked there.
I can see if it's in your driveway, if it's in your garage, if it's somewhere parked, not on the public road. But if it's on the public road, I don't know.
I mean, because we're, Judge, and I don't want to get too far in the civil, but what I'm just saying is that we're in no fault state. If we're talking about leaving a vehicle that's on the street, that's parked, that's not moving. Right. And let's say I don't drive it, I'm not driving it right now. And even if I just have safekeeping insurance, but it's an older car, it's not worth it for me to insure, Judge. That's an older Impala. I'm not gonna pay for any insurance, and I'm not required to. Now, if I had it positioned in a manner that could create an accident, certainly there might be some different liability here. But this is a parking infraction for a non-moving vehicle that they impounded the vehicle for, didn't give them the option for a private tow, which DPD policy allows for you. And it takes me back to what my original argument was. They used the investigatory search they used the inventory search to do an investigatory search. They're two different things. And I also submit that in an inventory search, He cannot disassemble aspects of the vehicle. That's a probable cause, ma'am. And I submit that he didn't have it.
All right, you cited people versus pool. Do you have that
P-O-O-L-E?
POOL? Is that what you said?
Yes.
Do you have the citation? Is it a Michigan case?
Yes. $199, dish at $261.
Is that 261, you said?
Yes.
All right, do you have anything further or anything in addition you'd like to argue?
This is the only thing that I would cite, that the legality of an impoundment of a defendant's car and of the intended inventory search, when it covers contrabands, as we discussed in people versus pool, the particulars, Judge, are important about what matters. So criminal arrest, a criminal type of citation here. What you have in this particular case is a parking infraction of a non-moving vehicle. I don't think that, well, I may mark, and I'm not going to get it. I think people versus pool is on.
All right, Ms. Bailey.
Your Honor, I do think that the officer, you can't tell from the defense's exhibit A whether or not the car was running when the officers first saw it. It is entirely possible that once the defendant saw the cop pull up behind him, he turned his car off. 100% possible, Your Honor, question of fact or prior fact as to when the car was on to when it was off, if at all. Therefore, Your Honor, I don't think that Officer Rumshaw's testimony is completely unparalleled. I think it provides a question of fact as to when he observed the vehicle was running and when that vehicle was subsequently turned off, Your Honor. Certainly blocking a driveway, having illegally tinted windows, expired registration, which I do believe that the defense exhibit A did indicate that there was only a 2020 registration. That is what I heard. I didn't hear anything about, yes, here's 2021.
No, there wasn't, I don't think there was any statement as to that, but there was clearly a different document that was provided to the officer along with the original document.
And Your Honor, I don't believe that that was a 2021 registration. But either way, the officers had cause to tow the vehicle for lack of insurance, for the tint, and for that, Your Honor, and I would argue that the inventory search was conducted prior to that, or was conducted subsequent to that. Your Honor is correct that an inventory and a tow does not have to be conducted after arrest. It is either going to impound the vehicle for some reason or the defendant is arrested. And I would argue that people have an
All right, thank you. The court heard from Bailey Bunchlag, who's a Detroit police officer. He's been so employed for 5 years, and he was working in his capacity as an officer on October 8th of 2021. He had a partner, Officer Patterson, and they were both in a fully marked Scout car. They were working in the area of Barlow and Cunningham in the city of Detroit. When they observed a vehicle that was blocking the driveway that he described had illegal tinted windows. Officer Bunchlag testified that he conducted a traffic stop of that vehicle. There was one occupant in the vehicle who was behind the driver's side of that vehicle. He asked that occupant for his driver's license, registration, and insurance. The driver, who was identified as Mr. McKinney, was able to provide the driver's license when he gave him expired registration and insurance. Officer Bunchlag testified that he observed suspected pry marks at the light area, the light portion inside of the vehicle, which caused him to be suspicious. He asked Mr. McKinney that he could search the vehicle, to which Mr. McKinney responded no. Based on the lack of insurance on the vehicle, and that Mr. McKinney was seated in the driver's side of the vehicle. And also, based on Rumschlag's memory of the events, he believed that that vehicle was operable on. He decided to impound the vehicle and conduct an inventory search. And while conducting that inventory search, he discovered a handgun inside of that light box where he saw the pry marks that was loaded with 15 9mm cartridges. The defendant was then arrested, and the court learned that the gun was unregistered, but that vehicle was in fact registered to Mr. McKinney, and that Mr. McKinney did not meet the age requirement to possess a CPL. The court received Defense Exhibit A, which was the body cam video of Officer Rumschlag, and on cross-examination, Rumschlag testified that he was unable from the video to be certain or ask, be certain whether or not the vehicle was on or not on when he approached. The court had an opportunity, Mr. McKinney is charged in count 1 with weapons carrying concealed. And the court had an opportunity to also review the case that was decided by counsel of People versus Pool at 199 Bishop 261, which is in 1990. So the court believes that with the testimony that was provided by Officer Rumschlag, that it does create a question of fact for the trier of fact. The court understands and believes that the officers wanted to get into that vehicle. I mean, he saw these marks and he needed a reason to get inside of that vehicle. The court is able to observe that there was at least one other officer in the rear, the passenger rear side of that vehicle, opened the door of the vehicle without the permission of the driver of the vehicle. However, the court believes that the fact that the vehicle was uninsured allows for the police to decide whether or not the vehicle was going to be impounded. And that once they decided to impound the vehicle, they have to conduct an inventory search, even in an area where they see that there is potential damage, and where they suspect there to be some evidence of a crime. So the court believes that it's a question of fact for the trier of fact, and it will be bound over to the third circuit court for bringing on the information 2 weeks from today, which is April 4th at 9.
Have a good day, everybody.
All right, thank you.
Yes, ma'am.
slow motion.
I'm good, how are you?
So I understand that there's a DSU on this file. Is that the case?
Just a second, Mr. Shedrow.
Morning, Your Honor.
Miss Bailey will be back in the courtroom in a moment. And we'll be able to
Okay. Thank you, Crystal, for calling.
You're welcome.
Miss Bailey, are you ready on Shaw?
Yes, Your Honor, I finally did get a response.
This is the people of the state of Michigan versus Harold Shaw Senior, case number 00F68109. Mr. Shaw is charged in count 1 with operating OUIL per se. Third, offense notice. May I have your appearance?
Good morning, Your Honor, Irvin Bailey on behalf of people P84009.
This is Honorable Court, George Shedrow, P41732, on behalf of Mr. Shaw.
Thank you, Mr. Shaw. I'm going to try to unmute you. And the court will note that Mr. Shaw is in the Zoom hearing room. It'll take 30 seconds to unmute, but he is present. Ms. Bailey, this matter is set for a continued probable cause hearing. How would you like to proceed?
Your Honor, at this time, my office will continue.
Did you hear that?
I couldn't hear anything the prosecutor said.
They're going to continue prosecuting this case. So the court is going to, schedule this for an in-person, well, we're going to order that discovery be provided to the defense no later than a week from today, which is the 28th. And we'll schedule this for an in-person exam to occur on, how is April 5th, Mr. Shedrow, at 11?
Not a good day, Your Honor.
April 6th?
I can be there, but I have to be at front of Judge Kusek at 9 o'clock. So hopefully we can get out of there by 10 o'clock, Your Honor.
I can give you 11 if that works.
That'll be better.
Okay, so April 6th at 11 a.m., Ms. Bailey will need a writ to get Mr. Shaw from the Michigan Department of Corrections. All right, we'll see you then.
Thank you.
All right, thank you.
Bye, everybody.
You're all set, Mr. Thompson.
Thank you.
All right, you're welcome. Madam Court Reporter, what date did that say? April 6th. April 6th. Okay, thank you. I'm ready to go on. Richardson. Ms. Barton, what's your first?
Sinclair was here first.
Are you ready on this case today? Yes, Your Honor. This is the people of the state of Michigan versus Alante Richardson, case number 21 F62742. Mr. Richardson is charged in count 1 with robbery armed, count 2 weapons firearms larceny, count 3 weapons firearms possession by felon, count 4 weapons carrying concealed, and counts 5 and 6 and 7 weapons felony firearm. He's placed on notice that he's a habitual offender second.
Good afternoon, Your Honor. Grim Bailey on behalf of people P84009.
Good morning. Oh, good morning. I called the case.
I'm sorry, I was talking with Mr. Richardson. I'm Christopher Sinclair, P80512. Here we have Mr. Richardson.
Thank you. All right, today's the date and time set for a preliminary examination of parties ready to proceed.
People are prepared.
Are there any preliminary matters?
Just one from the people, Your Honor. At this time, we will have a certified register of actions from the Third Circuit Court indicating that on November 2nd, 2020, the defendant was sentenced to a 10 CCW. Yeah, 10 CCW, Your Honor, making him ineligible to carry a firearm.
All right.
And he is still under the sentence of that conviction.
Any objection to the admission of People's Exhibit 1?
I haven't seen it, so I don't know if it's certified.
All right, can you please share that with the defense? I'm sorry, can you speak?
Rules allowed for examining.
All right, People's 1 is admitted at this time. Ms. Bailey, how many witnesses do you have?
I believe 2, Your Honor.
You can- The court is going to order that all witnesses are sequestered and that there is an exception for the officer in charge. Ms. Bailey, you can call your first witness.
Your Honor, at this time, the court would call Isam Amulaki to the stand.
Thank you. Sir, please come on in and provide the spelling of your name to the court. And sir, can you please turn towards me and raise your right hand? Do you swear or affirm that the testimony you provide? Please have a seat and then watch your step. There is a microphone that's right next to you. Pick up the entire base of that microphone and hold the microphone. And we need you to speak loudly and clearly into the microphone, okay?
Yes, ma'am.
All right, thank you. Spell your last name for me, please.
ELMULAKI.
Thank you. Your witness, Ms. Bailey.
Could you please restate your name for the record?
Islam Omalaki.
Mr. Amaleki, do you remember January 3rd, 2022?
Yes,
And on that date, did you have agency at 1 East State Fair?
yes,
Is that here in the city of Detroit,
yes,
County of Wayne?
yes.
What were you doing there?
I came in for a worker.
Oh, I'm sorry, just 1 second. So. I read the charges on the wrong case. This is the people of the state of Michigan versus Alante Richardson, case number 22-F55133. Mr. Richardson is charged in count 1 with robbery armed, count 2 assault with intent to rob while armed, count 3 weapons, ammunition, possession by felon, count 4 weapons, firearms, possession by felon, count 5 weapons, larceny, and count 6, 7, 8, 9, and 10 weapons, felony, firearm. He's placed on notice that he's a habitual offender section. All right, you can continue.
I do apologize, Your Honor. Mr. Sinclair, I do only represent Mr. Richardson on one of the 2 files.
That's correct.
So I'm sorry, why did you go to the address on the state fair?
I was called in because the guy that was working there, they called me in to work for him because he was sick. And he only had a couple hours of work left.
And when you arrived at work, what, if anything, did you see?
It was going smoothly at first, slow. And then that's when the incident happened.
Do you remember around what time the incident happened?
I remember it was in the morning, 5, 6 o'clock in the morning.
And how did the incident begin?
Well, a guy came in and bought something. We went back to the cooler door. And then next thing you know, I see me right beside me.
I need you just to speak a little louder. We're having a hard time hearing you.
So how did the incident begin?
You gave objection, that's the answer.
Well, Your Honor, I'm just re-asking the question because the court indicated that it had a hard time hearing the answer. So, well, technically, it might have been asked and answered to get a more clarified answer, Your Honor, for both the transcript and court. I think that the objection is improper.
All right.
It's not improper because the question was asked and the witness answered the question. It's not improper objection. Not whether it's something to be or not. It's definitely improper objection.
So the court is going to overrule the objection. I did not hear everything that Mr. Waldman stated.
Could you please just repeat for the court your answer?
We started by a man walking in the gas station. Now the third, yeah, bought something from me. Went to fight with the grab a drink. And then next thing you know, I see him right a couple of feet away from me.
So where were you when this happened?
Behind the register.
So did this person come behind the register next to you?
Objection is legal.
Overruled.
And what, if anything, happened after this person came and stood next to you?
Sorry, you said that again?
What, if anything, happened next?
Basically, I got up and I grabbed the gun that I had because I was terrified.
Why were you terrified?
So I looked at it.
Why were you terrified?
I was terrified because there was a man that I did not know what the man that was 100 feet away from me.
You said there was a man with a mask that was a couple feet away, and I didn't hear the last part.
While I was at work.
So what, if anything, happens after you grab the gun?
After I got the gun, we started a conversation with each other.
Objection to the use of the
Call roll.
Do you see this person here in the courtroom today?
Yes.
Could you please point to him and tell me something he's wearing?
A green shirt.
Your Honor, let the record reflect that the witness has identified the defendant.
The record will so reflect.
So, what, if any, conversation did you have with the defendant?
I was asking him, like, how did he get in? Like, why did he get in? Did he get out?
Okay, and what, if anything, did he do?
He was telling me to put the gun down. And they would hurt me.
What happened next?
I put the gun down. And then he shoved me with one arm. I grabbed it with the right.
Okay, so he shoved you with his right arm. Now, did he put his palm to your chest or something else?
Your response?
Your Honor, if Mr. Sinclair let me finish my question, he would have heard that it was not exactly what he was asking.
Okay, so you dealt with Tony the last time I was here. so,
All right,
I mean,
hold
we-
on.
I thought she was finished.
All right, so please, Ms. Bailey, direct your remarks or your responses to the court. And I don't need all the other information. So just tell me why it's not me.
Your Honor, I did ask if one thing or something else happened that's not illegal.
What was your question?
When you were shoved, the
Take your
defendant
side.
put his palm to your chest or something else?
It was more.
Okay, hold on. Let me move on. I love it.
So describe for me how you were shoved.
It was like by the whole arm. But
Let the record reflect that the witness is taking his right arm with a closed fist and is moving it out and away from himself at chest level. And what, if anything, happened after you were shoved?
after I was shoved, he grabbed the gun and put me in front of me.
What do you mean by that?
He grabbed the gun with the left hand, and then I had my base house in front of him. And he was holding it with one hand. And he got out and fired.
Where was he holding you?
But
I think the witness should talk about it.
Sir, can you please speak louder?
I said, on my back.
So, was the gun ever pointed at you?
No.
What, if anything, happened after the defendant grabbed the gun and was holding on to you?
He walked me outside. He told me to run.
And then what?
And then that's exactly what I ran 3 blocks, 4 blocks down, and went to find another gas station where I told the first to go.
Did you ever see the defendant take anything from the gas station?
Money.
When did you
I-
see that? Okay, so,
I didn't hear the answer.
Can you speak louder, sir?
The same day.
so when is, before you left the gas station, did you see him take?
Objection is with respect to our-
All right. Call roll.
When,
objection on that foundation.
All right, so lay foundation.
when during your interaction with the defendant, did you see him take money?
Objection on the foundation, that's the same question.
All right, I think that's how she establishes the foundation. He testified that he saw him take money, and now she's trying to figure out at what point he took the money.
His answer was, the witness said he saw Mr. Richardson take money some point that day. And the question was, at what point while the two of you were inside the gas station, did you see them? So that's different information.
Right.
It's assuming that's not evidence, and that's not a proper question of the foundation for when he saw, Mr. Richardson taking that day.
And then my question was changed to, when did you see the defendant take the money?
All right, so I'll allow that question. You can answer that.
Well, basically, after he grabbed the gun, he told me to grab everything at the register. which has been reviewed.
And when you go to do this, and what people will ask you,
Now, really,
do you think that the defendant had the ability to shoot you?
yes.
You know who the gun belongs to?
Yes,
Who does it belong to?
believe, Nash,
Objection, speculation.
Sustained.
I ask the question to answer.
All right, that answer is true.
How do you know who the gun belongs to?
the guy that I went in to work for,
Objection, lack of foundation to that question. Because we have established who the weapon actually did belong to.
All right. Sustained, ask another question.
The weapon that you, that was in the store, how did you know it was there?
It's a big gun. It has a little software, I guess.
Objection, unresponsive.
Your Honor, I don't think that was unresponsive.
I need to hear Ms. answer. Let me hear your answer. She asked you, how did you know the gun was there?
And he said it was a big gun and it was popular. There's not responsive. to that
Okay, but he
question.
hadn't completed what he was saying. So finish your answer. How did you know the gun was there?
The gun has a place where it stays. You can barely see it as soon as you walk in.
Okay, so the objection is overruled. You can ask another question.
Now, you said you can see it when you walk in. You walk into where?
To the front of the behind the station.
So if, correct me if I'm wrong, I'm just trying to clarify. If you are working behind the counter, it is easily visible?
It's under the desk.
And is it easily visible?
Yes, because of the big one.
Okay, thank you.
And how long have you worked, for this gas station?
Well, I didn't work that night. I was called in because.
Objection, unresponsive, and the questions there.
Your response?
Your Honor, if I sent that question, I understood my question, but, I think that it is in fact relevant. As an employee of the gas station, we would go to the foundation of, the gun and who owns the gun. Who's it was.
Is that really relevant in this case?
Yes, Your Honor.
Who the gun belongs to?
Yes, Your Honor. Because of count 5, Your Honor.
Right, but have you not already established that? Okay,
Your Honor,
so
the
I
answer was
will allow you to ask questions about how long he has worked at the store, the gas station.
So I know that you were called in that day, but in total, how long have you worked at the gas station?
A couple weeks.
And was the gun always there whenever you worked?
Yes.
You know who put it there?
I do not.
You know who gunned it?
Yes.
Objection, that question was asked.
I don't think you played a foundation. Did the gun belong to the person that came in the store and demanded money?
No.
How do you know? Your Honor, no further question.
Cross-examination.
Yes. One second, please. Good afternoon, sir. I said, good afternoon, sir.
Good afternoon.
How are you today? Okay, thank you for asking. So the person that entered the store was unarmed, right? They did not have a weapon?
Yes.
So, yes, they did not have a weapon? Or no? Well, let me ask you a different question, just so I'm clear, okay? The person that came into the store did not have a weapon?
No.
So the weapon that we're talking about was the weapon that you produced, right?
Yeah.
So the person that came in the store, they wouldn't have any knowledge or information as to whether that weapon was loaded, unloaded, or anything of that nature?
Yes.
They would not have that knowledge?
No.
Okay, the person would know that weapon was real or fake or not?
Either.
That's a yes or no question.
Speculation.
All right, what was your question?
The person who came into the store wouldn't have any knowledge as to whether that weapon was real or fake.
Do you know that if anyone came in the store would know if that gun was real or fake?
No.
Moving on, the person that came in the store was wearing a mask, right?
Yes.
So they had a hood on, yes?
Yes.
Their nose is covered,
Yes.
mouth is covered,
Yes.
and what were they wearing?
A Nike Tech.
You said what now?
A Nike Tech.
What's the Nike Tech?
Joggers.
Okay,
Gray sweatpants.
so it was just, so so all you saw was a person in sweats and a hoodie that came to the gas station, is that fair to say?
Yeah.
Yes.
Okay. And you didn't know the name of that person that came to the gas station, is that fair to say?
Yes.
It's fair that you do not know the name of that person?
I didn't know him until I figured out who it was.
Okay. And it's true to say, fair to say that you said the weapon was never pointed at you, right?
Yes.
So any fear that you had about the weapon was based on what you knew about the weapon and not what the person coming into the store knew about the weapon, fair to say?
Objection, Your Honor.
What's the objection?
What's your legal? Ms. Davis, what's your legal objection?
That calls for speculation. This witness doesn't know what, if anything, the person who, the defendant knew about the gun. So he can't answer that question because he doesn't know the defendant knows or didn't know about the gun.
That's not what he didn't, prosecutor can't tell the court what he knows or doesn't know. He can answer that question. He doesn't know that.
All right, so the objection is the same.
So any fear that you had about the condition of the weapon based on what you knew about the weapon, fair to say? You know how much money was taken from the store?
Not exactly.
You know, the money was taken off. One second, please. All right, there's a couple more questions. How do you pronounce your last name? Let me ask you that. Say it again? Oh, yeah, I just want to make sure I had it right. How do you pronounce your first name? Sam. Listen, a couple more questions. Money was taken on, I might have asked you already, I just didn't clarify. Money was taken that morning from where? Okay, was it inside or outside of the gas station?
Inside and outside because there's money taken from me as well.
Got it. Her first question.
All right, thank you. Any redirect this baby?
No, Your Honor, no redirect.
Thank you, Mr. Malaki. Are there any additional witnesses on behalf of the people?
Yes, Your Honor, at this time, we'll have Hudson, Elsa.
Sir, please come on in and provide the spelling of your name to the court. Give your name, the spelling of your name to the court. Sir.
I'm sorry. H-A-N-Z.
Sir, turn towards me. Watch your step, please. I need you to unplug that. Raise your right hand. Swear or affirm that the testimony you will provide is accurate. Okay. You can have a seat. Sorry, what was your laptop? Oh, no, ma'am. Okay. Can you grab the microphone that is right there? Take up the entire base of the microphone. You're gonna hold the microphone and speak loudly and clearly.
Okay.
Your witness.
Can you please restate your name for the record?
Hazel Sabari.
Mr. Altabani, do you remember January 3rd, 2022?
Yes.
And on or around that date, did you have occasion to go to One East State Fair?
Yes.
Then you're in the city of Detroit,
Yes.
County of Wayne?
Yes.
Why did you go there?
The night shift worker was robbed.
I didn't understand.
The employee was robbed.
And you said employee, does that mean that you were the owner of the store?
My brother is.
Objection leading, and that question had nothing to do with the answer that the witness gave.
All right, so it is a leading question. Ask another, are you the owner of the store?
I'm the brother of the owner.
Okay.
And so. What, if anything, did you see when you arrived at the store?
What did I see?
Yeah.
This station was unintended. The employee fled. He ran.
Objection, lack of foundation.
Police were there.
All right, so it's the thing, I'm gonna ask for an offer of proof as to this witness and as it relates to the charges that Mr. Richardson is charged. Oh, can I finish talking? All right, I just need to know what this witness is going to offer.
Objection, I'd ask the witness steps out of the room, the offer.
All right, sir, just step into the hallway, watch your step, watch that cord as you're stepping out of the hallway. All right, Ms. Bailey, you called Mr. Al-Sabahi as a witness to the scene. We heard from at least one witness that was there at the time that the incident of robbery occurred. Can you give the court an offer of proof as to what Mr. Al-Sabahi testified to?
Your Honor, aside from being the registered owner of the handgun, you would also be able to testify as to whether or not it was loaded with the handgun.
Okay, all right. All right, so then you can bring him back in.
Or his firearm. I apologize. I don't need it again. Okay.
Sir, you remain under oath. Just watch your step as you have a seat. Thank you. And you can grab the microphone, continue with your questions.
So, was any of your property taken from the store?
Yes.
What of your property was taken?
My firearm, it's an AK-47 Draco.
And how long had the firearm been in the store?
Oh, since I bought it, let's say about 3 years.
And do you know if the firearm was loaded in the store?
It was
Objection, lack of foundation. That has to put it right there.
All right, so lay a foundation as to how you would know that the weapon is loaded.
It is a first strike.
The court would.
What, if any, knowledge do you have as to whether or not the AK had ammunition in it or not?
I'm the one that loaded it.
Objection. Which one actually? I don't know. I didn't understand the question. It doesn't make, I don't understand the question. And before that question is asked, what I can make out of it, it needs to be foundation before that.
Your Honor, I'm attempting to lay foundation. How he would know if something was or something wasn't.
So why don't
laying the foundation.
All right, so why don't you ask him, like, when he last encountered the weapon? And what was his condition of it?
When did you last interact with the weapon prior to January 3rd?
I would say a couple of weeks before the robbery, I always inspect my weapons monthly.
And when you last inspected the weapon, what, if anything, can you tell me about
It's loaded.
And how is it loaded?
Banana.
Netflix?
Yes.
And how do you know it was loaded?
Because I'm the one that loaded it, and I always check every month.
You always- okay. You know how many rounds of ammunition would have been in the?
I believe.
Objection. The question calls for speculation at the beginning of the answer. It sounds like it's going to be.
Well, Your Honor, it's his gun. He testifies that he checks it. Testifies that he was the one who loaded it. So based on his information, he will be able to inform the court as to how many rounds of ammunition were in it the last time. he checked it. That's not speculation.
That wasn't the question. The question that she asked called for speculation.
All right, so do you know how many rounds were inside of the gun?
20.
Thank you.
Did you give anyone permission to take it?
No.
I have no further questions.
Cross-examination.
Good afternoon.
Good afternoon.
Pronounce your last name.
Elsavani.
Just quickly, you said the last time you inspected the weapon was approximately 3 weeks before the incident?
Yeah.
Sorry, say it one more
Yes,
time.
sir.
And on a day-to-day basis, how many employees come in and out of the gas station?
How do they come in and out?
I said on a day-to-day basis, how many employees come in?
Oh,
and out?
about 3.
Okay, so 3 per day?
Yeah, it's an 8-hour shift
Got it.
per employee.
So in the course of 3 weeks, it's fair to say that 21 people have come in and out of the gas station?
It's the same employees.
Let me finish asking my question.
Sure.
So is it fair to say that over the course of 3 weeks, is it fair to say that, let me do my math, 62, 63, less than 70, between 60 and 70 people have come into and out of like the employee portion of the gas station?
Is it fair to say 60 different people? No.
60 people have had interaction with the rear portion of the gas station, not necessarily different people, but 60 interactions, 5 people.
I'm going to object to that question.
It could be salesmen, it could be.
One, the question is confusing. 2, I think the witness testified before, that it is the same 3 employees that work these cycles. So the number of interactions, I think, is a mischaracterization. And the question is confusing as presented.
And judge, is not a mischaracterization of, an objection can be based on whether the opposing party likes the question or not. If it's compound, then I can fix a compound question. If it's not clear, I can ask a question that's more clear. But
All right, so I do think that the question is somewhat unclear because initially the first part of the question was about 60 people. And then I think it changed to 60 encounters. So if you can just be clear with your question.
yes, that's my tip to clarify the question. As I thought my way through it. So is it fair to say that there were 60 encounters, potential encounters with that weapon between the time that you last touched it and the time you did it?
When you say encounters, people touch the weapon?
No, people just going behind the counter, whether it's the same person, different person, or whatever.
Then, Your Honor, then that's speculation. We would have absolutely no idea how many times they've gone back and forth.
Judge, I'd ask the court allow the witness to answer the question. If he can answer it, then he can't.
He would be able to answer, he would be able to answer that question. Do you know how many encounters there were? Okay.
I'm sorry, I didn't hear your answer.
No, sir.
I think, one second, please. So after this incident, did you, were you able to, physically get a hold of the weapon?
After the incident,
Yes.
was I able to? No, I don't have one.
Okay. So you don't know what condition the weapon was in at the time, like at the time of this specific incident, is that fair to say?
No, the weapon was in great condition.
So you touched it, well, let me clarify that question. When I say condition, you don't know if the weapon had been shot, you don't know if the weapon had been fired, is that fair to say?
No, before the robbery, the weapon has not been fired. I know that.
How do you know that?
I mean, there was no incidents regarding the weapon being shot, like used.
So so the basis for your statement of you're absolutely, of you being absolutely sure that the weapon had been fired is that you had heard in situations with the weapon? Is that what you're saying?
Yes.
Okay, so you don't know if any of the people who worked the shift in those 3 weeks had unloaded the weapon at all?
I have no knowledge.
Okay, so fair to say the only thing you know is the condition of the weapon 3 weeks prior, correct?
Yeah.
Had you worked in the store,
I managed it.
You have to let me answer the question,
Sorry.
ask the question, excuse me, before you answer it. So is it fair to say that you worked in the store behind the counter during those 3 weeks?
No, I managed it.
When you say you manage, since you keep telling me you manage the place, what does that mean?
I make sure the employees are doing their job, all the orders are right, the place is clean, gas prices are where they're supposed to be.
And how do you do that?
I go in at least once, I go in at least once a day, 2 hours every time I go in, check up on stuff.
Okay. And when you go in, do you check the, see where the weapon is loaded or unloaded when you go in once a day, 2 hours a day?
Not every day, no.
Okay. I'll take the week.
Please mute yourself on the record.
No further questions?
Can you redirect? No. Okay, thank you. Sir, where you go? Yes, thank you. Watch your step, please. Are there any other witnesses on behalf of the people?
No, Your Honor.
Are there any witnesses on behalf of the defense?
No.
Okay, Ms. Bailey.
Your Honor, at this time, you can move for a bind over on all counts as charged. We did hear from victim Isam Angulaki that while working at the gas station located on Glenby State Fair here in the state of Detroit County of Wayne, he was encountered by the defendant, told him to put a gun down and picked up, shoved the victim, held the victim by the scruff of his neck, and told the victim to empty out the registered, Your Honor, of all money, which was then given to the defendant. The defendant was in fact holding a gun at the time. Therefore, people have met the burden on counts 1 and 2 and the accompanying felony firearms, Your Honor. We heard testimony that as far as employees were aware that the gun was loaded, therefore people have met their burden of proof on count 3 and accompanied with the People's Exhibit 1, which is a certified registered absence of defendant's conviction. The firearm in question belonged to Hazma al-Sahabi, who testified that he did not give anyone permission to take the weapon, that the weapon was loaded, and that it was his weapon. Therefore, the people have met the burden of proof on all counts, and I would ask the court to find over and charge.
All right, thank you. Argument, Mr. Smith.
Yeah, so I would object to the binding over on these files, on this file, on these counts. There's some challenges in the testimony. One being the identification of Mr. Richardson, the first witness to testify, clearly said that he didn't know who the person was that came into the store on the 3rd that morning. Testified he didn't know. He said the person was wearing a mask. He said the only thing he could see was just like his eyes and his nose. So there's no information on this record to substantiate him pointing to Mr. Richardson as the person that allegedly robbed him on the date of this incident. He also clearly testified that the person that came into the gas station was not armed, that person did not have a weapon, and it was that first witness, I'm going to say his name, Mr. Al-Malaki, who produced the weapon at the time of that incident. He also the witness testified that the person that came into the gas station never pointed a weapon at him or anything of that nature. And that's significant in this file. The second witness testified that he only came in contact with the weapon 3 weeks prior to this incident, and then it's testimony kind of morphed into him being into the store and looking at the weapon on a daily basis. But he didn't have any information as to the condition of the gun or the people may not have had contact with the weapon over the course of that 3-week period. So for the purpose of count 3, neither the witnesses are able, the second, excuse me, is not able to testify as to the condition of the weapon, as to whether it's loaded or unloaded. And the first witness will have more information as to the condition of the weapon, or whether it's loaded or unloaded, more so the person that was in the store, because it is a weapon that was under his control. Mr. Richardson's control. There's no testimony on the record to support count number 5 that the weapon was actually stolen. The offer of proof that was placed on the record as to Mr. Al-Sabahi's testimony is that he was going to testify to being the owner of the weapon, and he didn't offer any testimony as to the location of the weapon or if it was taken, if he was ever able to find it, nor did the first witness testify about anything concerning whether the weapon was taken, or whether they had contact with the weapon after the fact, whether the weapon was actually found, or anything of that nature. So that's my argument to that, and my argument to cover the base of the charges is identification. The court, the judicial court, of course, is in a position to ascertain the credibility and witnesses that come before the court. There's no foundation to say that to establish that the first witness, Mr. Al-Malaki, knew the identity or the name of the person that was innocent. He said it would, so you can't that he knows the name of the person. And it seems that he was pointing to the person, the only person in the world who doesn't trust him. And I'd ask the court to not find this matter.
Thank you. The court first received People's 1, which was a certified register of action, indicating that Mr. Richardson had been convicted of attempted death back on November 2nd, 2020. The court heard from Mr. Al-Malaki, who testified on January 3rd this year. He was working at 1 East State Fair, which is Detroit. He was called to work early, and he believed that it was about 5 or 6 in the morning. He said the person came in the gas station, bought something from him, then went back to the cooler area. When the person came near him, he said that the person had a mask on. It frightened him, to which he grabbed the gun that was located in the area where he was. He identified the defendant, Mr. Richardson, as the person that came into the door. He said that they had a conversation, that he told the defendant to leave the store, and that the defendant said, put the gun down. And that Mr. Malachi put the gun down, and that's when the defendant shoved him by the arm and grabbed the gun and held it on him while holding the back of his shirt. He said the gun was not pointed, but that the defendant then demanded that Mr. Malachi obtain the items from the register and give them to him. Mr. Malachi also said that the defendant walked with him outside and told him to run, which he ran approximately 3 blocks to another store, contacted the clerk, and told the clerk to call the police. Mr. Malachi said that gun was in the store prior to the defendant arriving in the store. The court also heard from Asma Al-Sabahi, who testified that his brother owns the gas station located at 1 East State Fair in the city of Detroit, that he owns an AK-47 gray coat that is stored at that location, and that he inspects it monthly. The last time he inspected, it was about 3 weeks before. He said it was loaded with a banana clip, and it had approximately 20 rounds inside. And that gun was not there when he went to the location on January 3rd of this year. Mr. Richardson is charged in count 1, robbery armed, and in count 2, assault with intent to rob while armed. The court believes that the people have met the burden of proof by a probable cause standard in showing that the defendant did in fact commit larceny of money and use violence against Mr. Al-Malachi when he took the gun from him and demanded the items that were in the register. The court understands the defense's argument as to identification, but the record reflects that Mr. Al-Malachi was able to point to and identify Mr. Richardson as being the person who entered the store on the day in question. So I think it's a question of fact. In count 3, weapons, ammunition, possession by felon, the court is satisfied that the people met the burden of proof by a probable cause standard in showing that Mr. Richardson did in fact possess ammunition, which the owner of the gun said was in that weapon. He last inspected it 3 weeks prior. So the court does think that there is probable cause to find McKinney over on that charge, as well as in count 4, weapons, firearms, possession by felon. Along with the certified register of actions, the court is satisfied that the defendant in fact possess a firearm when being ineligible to do so because of his prior criminal conviction. In count 5, weapons, firearms, larceny, the court is satisfied that that weapon, the AK-47 that was stored in the gas station that belonged to Mr. Al-Sabahi, was in fact taken when Mr. Richardson entered the store on the date in question. So he will be found over on that charge, as well as the following felony firearm counts that correspond with the armed robbery, assault with intent to rob while armed, felon in possession of ammunition, felon in possession of a firearm, as well as larceny of a firearm. Mr. Richardson will be arraigned a week from today, which is the 28th of March at 9 a.m. Ms. Bailey, how many witnesses do you have on the next case? Can you do that before one?
Possibly. Or Ms. Martin is here.
Ms. Martin's here. She's been here. Ms. Martin, you ready?
Yes.
This is the people of the state of Michigan versus Alante Richardson. Case number 21 F62742. Mr. Richardson is charged in count 1 with robbery armed, count 2 weapons, larceny, firearms, count 3 weapons, firearms, possession by felon, count 4 weapons carrying concealed, and count 5 and 6, as well as count 7 weapons, felony, firearm. He's placed on notice that he's a habitual offender. Second, may have your appearance.
Good afternoon, Your Honor, Brenda Bailey on behalf of the people of the 84009.
And Judge, if I may interrupt briefly, Mr. Richardson has expressed me that he would like to retain on the second one, which I don't have a problem. I just need time to get started. I'm ready for
Has he retained you?
No.
He has not retained you as of yet. All right, Mr. Richardson, are you able to hire Mr. Sinclair to represent you in this case? I can hear you. When will that be done?
Yes, Your Honor.
All right.
Your Honor, I want Mr. Wilson more time that he wants.
Oh, you're waiting all day.
I know, but I did have another exam upstairs, so I wasn't.
All right. No, we definitely want Mr. Richardson to have the attorney that he wants. We want to be prepared to proceed on the case. Thank you for being here and being prepared to go.
No problem.
All right, so then why don't we come back tomorrow over Zoom to make sure that you're retained on the case, and then we'll schedule an exam for this case. All right.
And the next thing, my understanding that, for initially my understanding, there was a issue that was working with the box, and then, I don't know that good. So I'm assuming because we didn't address at the top of the exam, that it's just, for the one file.
So I don't know that it matters what violence is ordered for. I do have a DSU, if you'd like the court to consider it and to read what the findings are. I can do that.
Well, the only reason I make a distinction is sometimes it matters more so. It's a case by case situation, but it allows me to do it.
So it just lists all of his charges on both cases, what the DSU, the pre-file investigation summary lists. I'll go over the information that it states. So the present bond is $100,000 cash and surety with no contact with the victim directly or indirectly, or at 19854 Woodward in the city of Detroit. It also indicates that on the case that we just heard, his bond is $100,000 cash and surety with tether, no weapons, and may not go to the Citgo gas station. It states that he has aliases that he's used in the past, and he does have a failure to appear. It also indicates that he is on active probation, however, he's not on active parole. Under community ties, it indicates that on March 24th, pre-trial services interviewed Mr. Richardson at the Wayne County Jail via telephone, at which time he provided the following information. He stated that he lived for 1 year and 4 months on Woodward Heights in Hazel Park with his girlfriend, Ms. Hunter. Prior to that, he lived with his mother, Ms. Sewell, on Lexington Lane in Chesterfield, Michigan, and he lived there for about 3 years. He stated that he would reside with the parent of his child, Ms. Harris, on Dover and Warren if he was released on bond. And he provided his girlfriend, Ms. Hunter, and the parent of his child, Ms. Harris, as his personal references. The writer spoke with his mother, who verified his residency with some discrepancies. Ms. Sewell stated at the time of his arrest that he was living with his youngest daughter's mother, Ms. Harris. somewhere around 15 or 16 Mile Road in Macomb County. Prior to that, she stated that he lived with Ms. Harris at her mother's house, but then moved to a hotel due to reconstruction of the house. Before that, his mother said that he lived with a person by the name of Diamond, and she didn't know the exact address. Additionally, Ms. Sewell stated that the defendant did not live with her on Lexington Lane since he was 23 or 24 years of age. The writer also spoke with Ms. Harris, who stated that he was living with her on Dover at the time of his arrest. Prior to that, they lived together in Sterling Heights. Ms. Harris indicated that the total amount of time she and the defendant lived between Warren and Sterling Heights was 1 year. Additionally, Ms. Harris stated that prior to the aforementioned 1 year, his probation address was in Hazel Park with his girlfriend. She did say that he will be allowed to reside with her on Dover and Warren if released on bond. Under personal history, Mr. Richardson was born in October of '94. He lived in Michigan his entire life. His mother verified his date of birth and that he lived in Michigan. She spelled his name. She thought his name was spelled differently. Mr. Richardson is single with 4 children whom he supports financially. And his mother verified that he supports his 4 daughters and that he has a son on the way. He last completed 11th grade at Kettering. And he did attend Flip the Script part-time at the time of his arrest. He's in good physical and mental health, no mental health conditions, but might suffer from asthma, but was not born. He uses marijuana 1 to 2 a week, and his mother didn't know that he used any drugs. Under employment, he's been employed for the past 2 years at Tone's Barbershop, and his mother verified that employment. The writer tried to contact the barbershop, but they say by all indications the establishment is no longer open. The recommendation is that the bond be reduced to 100,000 cash or 10% GPS tether, and an added condition to have no direct or indirect contact with the complaining witness. Is there anything more you'd like to add, Mr. Lucy?
I just asked the court to adopt that recommendation. The court is, of course, fully, well, not fully, I'd ask the court to adopt the recommendation for bond on both files. It's my understanding that the DSU address is directed at both. The court is, of course, aware of facts and circumstances that lead us to report on the file that court just heard the exam on. And I think it's significant that that Mr. Richardson did not come to that location with a weapon on that day. He was not armed, and that the person who is interestingly identified as Mr. Richardson, the court acknowledged that that's a question of fact based on what the court heard during the testimony. That the witness produced the weapon, not Mr. Richardson, or the person identified as Mr. Richardson. I think that is a significant issue because it speaks to the mindset of the person that arrived at the gas station and that they didn't show up for any harmful or dangerous intentions, if I can say it that way. I don't have the information on the other file, but of course, the writer of the report has the information on that file. And I do, they have all the information about Mr. Richardson's background, and still decided to make that recommendation of the 100,000 GPS. I'm asking for it to adopt the recommendation on
Bailey.
If people would oppose any reduction in bond, or oppose any reduction in bond. We heard that while the defendant did not enter the store with a weapon, he certainly seized an opportunity as soon as it was presented and armed himself with a weapon, Your Honor, and proceeded to then take money. I think that his entering the store, purchasing something, walking away, and then coming back around the counter to where the employee was, does indicate that he did have, in fact, the intent to rob the store while in there, Your Honor. That is again a question of fact. But he then actually escalated the situation by gaining possession of a weapon and forcefully, while in possession of a weapon, making an employee open the cash register and empty it out to him. I do believe there was also testimony that the defendant did take anything that the plaintiff witness had on him at the time. Your Honor, I think a reduction in bond would be inappropriate, especially given the court's recitation of multiple aliases, multiple failed to appears, complete inconsistency of addresses within at least a regular period of time, Your Honor. The fact that he is currently on probation, or at least was at the time on probation, Your Honor, indicates that this witness, or not this witness, this defendant is a danger to the community. Your Honor, I do ask the bond.
All right, thank you. The court has had an opportunity to review the bond in this case, which is $100,000 cash or no contact. The court has reviewed the pre-trial investigation summary. And the court has also listened to the argument from both the defense and the prosecution, as well as taken into consideration the testimony that the court has heard as related to the robbery that occurred on January 3rd of 2022. The court is not going to amend the bond at this time. I think that it is reasonable given the fact that Mr. Richardson does have two cases that are pending, and I'm going to leave it as it is as of right now. So we'll see you tomorrow at 8:30 a.m. on the second case.
I'll be in Warren first thing in the morning, so it might be after 8:30.
That's fine.